Hello guys, so in today's video let us try to cover, a lot of people were asking about one topic, that is, can we cover all the textbook questions that is there in our CA Inter Law. So today let us try to focus on covering all your Inter textbook law questions. Wherever there is explanation required to be given, I'll be giving that explanation. If it's easy, let us try to see, let us try to move on. And also let us try to focus on how do we present the answers, what are the keywords, let us try to focus on that. And of course, there are some places where I feel personally that there are some questions which are wrong. I'll be trying to point them out from my end. So said and done, let us start your first chapter. Okay. MCQs. Green Limited is incorporated. This is only your textbook questions. Green Limited is incorporated on 3rd Jan 2023. And one more thing, what you guys can do alongside is try to pause. You guys also try to answer from your end. I know not every one of you would have solved this textbook questions on your own at least. So sit back. Probably less than 3 hours. We'll be completing the entire, the questions of all the chapters. So it's a good thing before you go for your exam. So Green Limited is incorporated on 3rd Jan 2023. As per the Companies Act 2013, what will be the financial year for the company? So we know that if at all you are incorporated on or after 1st of Jan, your financial year will end in the next year. So it is going to be people 2024. Roma, along with her 6 friends, has incorporated Roma Trading Limited in May 2023. The paid-up share capital of the company is 2 crores. Further, in April 2024, she noticed that in the last financial year, the turnover of the company was well below 40 crores. Advise whether the company can be treated as small company. They are taking still the previous limits only, because it's textbook questions, and for your exam there is an amendment. The small company limits are people. It's a company whose paid up share capital does not exceed 10 crore. It's a company whose turnover does not exceed 100 crore. So this is your new small company limits. Remember this and go from your exam point of view. Coming to these people, it clearly says it's Roma Trading Limited and hence it's a public company. So a public company cannot be called as a small company. So answer is people only for a private company. Abhilasha and Amrita have incorporated a not-for-profit private limited which is registered under Section 8. One of their friends has informed them that their company can be categorized as a small company. Same thing, what and all cannot be considered as small company? It is your public companies, holding subsidiary, Section 8 company, statutory companies cannot be considered as people small company. So it is a non-profit, basically a Section 8 company, and hence I cannot categorize this company as a small company. The status of small company cannot be bestowed on Section 8 company. Associate company in relation to another company means a company in which that other has a significant influence but which is not a subsidiary company. Here what do you mean by significant influence? 20% of total voting power. MNP Private Limited is a company registered under Companies Act 2013 with a paid up capital of 2 crore and turnover of 60 crore. Explain the meaning of small company and examine the following in accordance with the provision. Whether MNP Private Limited can avail the status of small company? Answer is in today's date, so yes. What will be your answer if turnover of the company is 30 crore? Today also the answer is still yes only, right? Because paid up capital turnover, if it is both within 10 and 100 crore, the company will be called as a small company. Easy one. Whenever you are presenting your answer, try to remember. Now, if I have to present this, how will I present this? I'll try to divide my question or I'll try to divide my answer into 3 paragraphs. What is that? The first paragraph will always try to speak about only the provision of law. The next paragraph I'll have to concentrate on people is facts. The third paragraph I'll try to concentrate on is people conclusion. So in provision, in facts, in conclusion, in provision now, here I am only and only going to write about the small company definition. That is what people, I'll be clearly writing as per section 2 clause 85 of Companies Act. A small company means a company other than public company having a paid up share capital not exceeding 10 crore and a turnover not exceeding 100 crore, but which does not include all of that. So I'll establish my provision. Here people, please don't keep these things in mind. Please don't use your own words. Words in the sense I'm trying to tell you here is, do not try to write something which is not required, and keywords are very, very important. Now, when I say keywords, here paid up share capital, turnover, these are the keywords. So for that there is no alternative. Please write down those things as it is. And people do not write conclusion in the first paragraph. That means don't write yes or a no. All of this is not required in the first paragraph. The second thing people remember, very, very important, the facts of the case, keep it as simple as possible. Now, what do I mean by as simple as possible? The facts of the case, people, you know, I know, invigilator know, everyone in this world knows that you're not using your brain here. You're just copy pasting from the question. So people keep the facts as simple as possible. Max to max 3 lines, more than sufficient. And remember, a very, very important tip. It's okay even if you do not write the facts in the last 1 hour of your exam. It's okay, leave it. Because time management will become difficult, people. In the last 1 hour, it's okay. So this is just the people, I would say, these are not very core aspects to evaluate. These are just something which is there on the face of it. So this alone will not give you a mark. And then come to conclusion. In conclusion, people, make sure you use the names given in the question. This is very, very important. Names in the question should be used. That means what? Now in our case, if they have given us MNP Limited, please use those names. Now write down, like referring to the facts, referring to the provision of the case, we can hereby conclude that MNP can be considered as small company. So this words will be there in the question itself. See whether MNP can avail the status of small company. Your answer will be simple. Now there are 2 questions, right? Please write it this way. Conclusion 1. Hence MNP Limited can avail the status. See, I am not using my words at all. Can avail the status of small company as its paid up share capital and turnover is within the limits. Yes, if you write it this way, people, and please see can avail, underline that. More than sufficient, people. So this is what will fetch you the marks. And write down the conclusion too. Here also. See, how will they ask you, what will be your answer? You can write it this way, right? My answer, the answer would remain the same. The answer would remain same. Considering the new limits, yes, you are still considered as a small company only. See, you are making it interactive. Rather than just writing, copy pasting the question, copy pasting the provision, you're making it interactive. The chances of you getting more marks is always higher. Remember this and go. Clear? Yes? Okay. Next one, Flora Fauna Limited was registered as a public company. There are 230 members in the company as noted below. What are the 230 companies? They have given, 230 members in the company. So they have given the list of all their members, people. If we add everyone, the number is coming to 230 it seems. The question is, the board of directors, the company proposed to convert it into a private company. Also advise whether the reduction in the number of members is necessary. Now what is they telling you? They want to convert the public company into a private company. We know that there should not be more than 200 members. So they are asking you, if this company converts itself into a private company, should they reduce the number of members? Is it required? People here, I tell you one mistake that the book has given. What is that? See, ex-employees, you should not count them. And you will always count them, the joint shareholders, as one. So 5 couples holding shares. So what will we count 10 as? We will count 10 as 5. And others are 145. That means what people, our number came to 150. I will not count my employees, I will not count my ex-employees. Now because of that, what happened, people? Now the question is, whether should I count the directors and relatives or not? Here people, if you ask me, the institute's answering or reasoning according to me is wrong. According to me, even the directors also are the employees of the company only. So you will be, technically you have to exclude them also from the number. So according to me, the directors and relatives grouping is wrong. You're not supposed to group it together. Now, why they do this is, people, just to complicate the questions, they do this. If they are given it as director separately, relative separately, you would have done it properly. You would have excluded the directors from counting, you would have included the relatives. Correct? You would have done like that, but yes, just to increase the difficulty level, they give it, and according to me, this grouping itself is wrong. Yeah? Now, I don't know in this how many is relatives and how many is directors. So that's what the institute has done. They have added everyone. According to me, this answering itself is wrong. But yes, so this is what I said, wherever it is wrong, I'll call it out and say it is wrong, according to me. Yes, clear? So this is what is the solution. They say adding everyone, it is coming to 200. So even if after converting from public to private, they need not have to reduce the number of members. Clear? All of you? Make sense? That's all. Next one, people, chapter 2. Entrenchment enhance the protection. Modern Furniture Limited, an existing private company, willing to insert the provisions for entrenchment. It can amend the article by passing an ordinary resolution. It can amend the article by passing a special resolution. Can amend the article agreed by all members. Can amend the article. Again, there is a wrong thing, people. What is that? See, the answer they have given is, people, you can amend the articles agreed by all the members they have given. Correct? Huh? But look at the question, people. Entrenchments enhance the protection. There is a company called as Modern Furniture Limited, an existing private company. Private company limited. How, people? So, question itself is wrong. Now, people will keep asking me, sir, how will we get answer in moderation? Moderation you will get like this only. Yeah, that 1 mark now will become extra. Then you will get excess mark only. I hope you know, people, entrenchment of articles, if it's in the case of private company, all the members have to agree. If it's in the case of public company, you need to pass a special resolution. Here they are calling it as a private company, but name is public company. According to me, is wrong. Okay. Today is July 2024. Mr. Nilanjan Chattopadhyay, a 24-year-old Indian youngster who returned back to India in Jan month 2024, after completing his education in bionutrient and willing to form an OPC, but not sure about the requirements or preconditions regarding the eligibility. He read some articles on provisions related to OPC and concluded that OPC can be formed by Indian citizen. He can't form OPC because in immediate previous year, he was not resident in India. So answer is, both the conclusions are valid. None of the conclusion is valid. First conclusion is invalid. Second conclusion is invalid. What? He can't form OPC because in the immediate previous year he was not resident in India. Why is this conclusion coming into picture, people? Because who can start OPC in India, whether you are a resident or otherwise. Or otherwise means even if you have not stayed in India, you can still take up a OPC. In case of an application for reservation of name or for change of its name by an existing company, the registrar may reserve the name for a period of 60 days. Again, people, according to me, this is also wrong. Why? In case of an application for reservation of name, this is the case of people new company, or for change of its name by an existing company. So technically you are grouping both, people. If it's the first name, people, first time, this has to be 20 days. If it's an existing company, people, it is 60 days. The name shall be reserved. For both, there are two different provisions. So if an existing company is planning to change its name, then you will apply for the name and such name will be reserved for a period of 60 days. Yeah? The question could have been a little more clear. But yes, 60 days. Modern Furniture Incorporated on 30th June 2022, its directors filed a declaration under section 10(1)(a) regarding receipt of payment, that is value of shares, to register on 18th April 2023. Okay, the company and its officers shall be charged with penalty of. Okay, it's a penalty driven question, but I hope you know. It's section 10(a) people, certificate of commencement of business. You need to file certificate of commencement of business within 180 days of incorporation. In the given case, people, incorporation is 30th June. Here it is April, so it is definitely beyond 180 days. So there is going to be a liability, 50,000 and 1 lakh respectively. ITC Limited changed its name to ITC Limited. Company and its officers thereat made default by failing to make alteration in every issued copy of memorandum and articles. In this context, you are required to pick incorrect statements out of the following. Incorrect statements. When you're reading the question, make sure you guys pay attention to whether correct or incorrect or they can play with your mind. Alteration should be made to every copy of MOA or AOA because these are considered as public documents. Alteration should be made to every copy, whether it is in electronic form or in otherwise. Penalty shall be ₹1,000 for every copy of the articles issued without such alteration. Correct? So alteration. So all these are correct statements only, people. Yes. So what is the answer? None of 1, 2 and 3. Yadav Dairy Products Private Limited has registered its articles along with memorandum at the time of registration of company in December 2019. Now directors of the company are of the view that provisions of articles regarding forfeiture of shares should not be changed except by a resolution of 90% majority. While as per section 14 of Companies Act 2013, articles may be changed by passing a special resolution only. One of the directors said that they cannot make a provision against the Companies Act. You are required to advise the company on this matter. What is this case, people? My provision will be as per section 5. You can amend the articles of association. You can make the articles more restrictive or you can make the articles more stricter. And that itself will be called as what, people? Entrenchment of articles of association. In the case of private company, people, it can be entrenched only after being approved by all the members. So in the given case, people, entrenchment is possible. It is just making the company law more restrictive and more stricter. You are not defeating the provision of companies law. So Yadav Dairy Products can go ahead and alter its articles as in to include the entrenchment provision into their articles. Possible. A group of individuals intended to form a club, namely Budding Pilots Flying Club, as limited liability company to impart classroom teaching and aircraft flight training to trainee pilots. It was decided to form a limited liability company for charitable purpose under section 8 of the company for a period of 10 years, and thereafter the club will be dissolved and surplus of the assets over the liabilities, if any, will be distributed amongst the members as a usual procedure allowed under the Companies Act. Examine the feasibility of the proposal and advise the promoters considering the provision of Companies Act. What is this, people? First of all, we know, can we do it, people? Answer is no. Section 8 company, you cannot have declaration of dividends. It's prohibited. Upon winding up, people, you're not supposed to take the surplus to the shareholders. You're supposed to put the money back into the business itself. You're not supposed to take it into the shareholders account. So in the given case, people, no, the proposal is not advisable. 100%. Yeah. Alpha School started imparting education on 1st April 2010 with the sole objective of providing education to children of weaker society, either free of cost or at nominal fees. However, on 30th March 24, it came to the knowledge of the central government that the said school was operating by violating the objects of the objective clause, due to which it was granted the status of Section 8 company. Describe what powers does the central government has. Remember, people, whenever a Section 8 company does not carry on the objects as per its object clause, or it gets involved into any fraudulent business people, in such case, what is going to happen? Central government can revoke your license, and they can even convert you into a private company or a public company, or central government can even wind up your company, or central government can even pass an order to amalgamate your company with any other Section 8 company having similar objects. Upon winding up, what will happen, people? All the liabilities of the Section 8 company first will be repaid. If you still have any excess money left, people, that money will be transferred to insolvency and bankruptcy fund. That is what will happen in the given case. XY Limited has its registered office at Mumbai in the state of Maharashtra. For better administrative convenience, the company wants to shift its registered office from Mumbai to Pune. Okay, what formalities the company has to comply with under the provision of Companies Act for shifting its registered office? In the given case, what is happening, people? From jurisdiction of one ROC to another ROC, you are shifting your registered office. In such case, what is going to happen, people? I need to take the approval of people. By default, board approval is mandatory. In addition to that, people, I'll also take the approval from the shareholders. I'll pass special resolution. And this special resolution has to be through, people, postal ballot. Next thing, people, board resolution, special resolution, and I'll also have to take the approval, people, RD. RD's approval becomes mandatory. So with all of these, people, can I go for shifting of registered office? Absolutely yes. Done. Anushka Security Equipments Limited is a manufacturer of CCTV cameras. It has raised rupees 100 crore through public issue of its equity shares. For starting one more unit of CCTV camera manufacturing. It has utilized 10 crore rupees, and then it realized that its existing business has no potential for expansion because government has reduced customs duty on import of CCTV cameras. Hence, imported cameras from China are cheaper than its own manufacturing. Now it wants to utilize the remaining amount in mobile app development business by adding a new object clause in its MOA. Does the Companies Act allows a change of object? If not, then what advice will you give to the company? If yes, then give steps to be followed. Yes, people. Remember, again, the question has been answered only from one perspective, people, section 13. Again, if you ask me, this alone is not sufficient. You need to answer this question as per section 27. So if we answer this question as per section 13, is it right? I would say 80% the question belongs to section 27, 20% belongs to section 13. So according to me, this is a wrong grouping, people. It should have been actually section 27. Because when a company has raised money from public by issuing prospectus, remember, you're not supposed to change the name of the company, objects of the company. For that, you need to follow section 27. What do I have to follow? I have to call the shareholders for a meeting. I have to pass special resolution, postal ballot. If shareholders are not okay with it, you should give them an opportunity of exit. So for the dissenting shareholders, you need to give an exit opportunity. And what else? You have to publish it in the newspaper as well as on the website of the company. After doing all of these, people, yes, you can add object clause to your MOA. That is okay. But all these things you will have to follow. That is mandatory. Yes. Yeah. So wherever it is there, I have written in the red. The object clause of Memorandum of Vivek Industries Limited empowers it to carry on the real estate business and any other business that is allied to it. Due to a downward trend in real estate business, the management of the company has decided to take up the business of food processing activity. The company wants to alter its memorandum so as to include the food processing business in its object clause. Now see, this is the direct scenario based on, people, your object clause. What is the scenario? The scenario is very clear. Our object class said X, now I want to add Y. Can I do it? Yes. Call all your shareholders for a meeting, pass a special resolution, file MGT14 with ROC, sufficient people, you are free to now take up any new object, absolutely possible. So the only thing you guys need to do here is people alter your MOA. That is my provision. That's all done. Yeah, this is the case of section 13. The person not being members dealing with the company are always protected by the doctrine of indoor management. Explain doctrine, also explain doctrine of constructor notice will apply. What are the people? Doctrine of indoor management is nothing but a scenario where the company or the law protects the outsiders from the company. That scenario is called as doctrine of indoor management. Doctrine of constructor notice is the opposite of it. We try to protect the company from the outsiders. So whenever anyone is entering into a contract with the company, they are deemed to be aware of all the information about the company, whether they have disclosed it or not, because all documents sit in the public domain. And when there are some exceptions to doctrine of indoor management as well, knowledge of irregularity, suspicion of irregularity, and forgery. Remember and go. Next one, Manglu and Friends got registered a company in the name of Taxman Advisory Private Limited. Taxman is a registered trademark. After 5 years, when the owner of trademark came to know about the same, it filed an application with relevant authority. Can the company be compelled to change its name by the owner of trademark? Can the owner of registered trademark request the company and then company change its name at its discretion? The scenario people, section 16, whenever a company with similar name of a company or registered trademark gets registered people, you need to file an application to central government within 3 years of such duplicate company getting registered. Now what will central government do? If central government is convinced people, they will pass an order to such duplicate company to change its name. If the company does not change its name on its own, within 3 months from the order passed by central government, the central government itself will allot a new name. Sir, whereas in the given scenario, because it has been 5 years, so the company is barred by limitation. You cannot go beyond 3 years, not possible. So in this case, what can the company do? The company should people go and request. So if you request it, if the company want to change, it will change. But legally they are not bound to. But yes, it's just a request, then absolutely fine. A request can be just a request. Yes. Explain in the light of provision of Companies Act the circumstances under which a subsidiary company can become member of its holding company. What people? You are already a subsidiary, you were already a shareholder before becoming a subsidiary company in the capacity of a trustee or on behalf of the deceased. You can hold it as a legal representative on behalf of the deceased. These are the 3 exceptions. Sri Lakshmi Electricals, section 19 basically. Sri Lakshmi Electricals Limited is a company in which Hanuman Power Suppliers Limited is holding 60% of its paid up share capital. One of the shareholders of H made a charitable trust and donated his 10% of shares in H and 50 crore to the trust. He appointed S as the trustee. All the assets of the trust are held in the name of S. Can a subsidiary hold shares in its holding company in this way? Is it possible? We have already seen people. Generally, subsidiary company cannot hold, but there are exceptions. One of it is people is trustee. So in trustee, yes, I can. Explain the provision of Companies Act 2013 relating to service of documents on a company and the members of the company. So what are the people? If you want to send any documents to the company, what are the different ways to send people? I can send it by registered post, speed post, courier, or personally going and giving, or electronic mode. Sir, what if I am giving it to the registrar? If I am giving it to the registrar or any member, then cut copy paste, registered post, speed post, courier, same thing only. One extra thing will come, that is post. So ordinary post is also included. So you can either give it by ordinary post or you can even give it by speed post. Both are possible. So registered post, ordinary post. So in when you are giving any notice to the registrar or member, ordinary post also gets added. What is the, in general, what is the difference between ordinary post and registered post, people? Is there a difference between ordinary post and registered post and speed post? Is there a difference? Speed post, you know, people, it comes zhub. Correct? What is the registered post, people? Registered post is nothing but whenever upon delivery, they will take your signature. The postman will take your signature. If that is the case, we call such post as registered post. Ordinary post means nothing but, people, it will be your post, but you cannot find it in front of your house. It will be somewhere. It might be in front of the gate. It can be going to the next person's house. So your post, which will just be put somewhere there, that is only called as ordinary post. But on a very lighter note it is, but yes. Next one, Parag Constructions Limited is a leading infrastructure company. One of the directors of the company, Mr. Parag, has been signing all construction contracts on behalf of company for many years. All the parties who ever deal with the company know Mr. Parag very well. Company has got a very important construction contract from a renowned software company. Parag Constructions will do construction for this site in partnership with a local contractor, Feroz Bhai. Mr. Parag signed a partnership deed with Feroz Bhai on behalf of company because he has an implied authority. Later in a dispute, company denied to accept liability as a partner. Can the company deny its liability as a partner? This is the case of section 22, people. On implied authority, you cannot bind the company on all the contracts. So in the given case, you need a specific authority. Either someone should have appointed you as an authorized person by affixing a common seal, or two directors, or if a company has one company secretary and one director should sign the document and make you liable. Should make you authorized representative. In our case, implied authority will not work. Correct? Remember, important. Next one, let us look at chapter 3, prospectus and allotment of securities. Modern Furniture Limited issued a document containing offer of securities for sale, that is considered as deemed prospectus under section 25, which requires such document must contain certain matters in addition to those required under section 26. Which of the following are correct requirements? Again, people, here there is one mistake. They have given 1 or 3 only. The answer should have not been or, people, the answer should have been and. Correct? The answer should have been and. 1 or 3 only they have given, it should be and. 1 or 2 it is. They have given 1 or 2, it should have been 1 and 2. Yeah? It is not or, it is and. Both should be there. Section 40 of Companies Act 2013 requires every company shall make an application to 1 or more recognized stock exchange or exchanges before making a public offer. Madhav Casting Limited filed an application to 3 exchanges for the securities to be dealt within such stock exchange. It received permission from a couple of them and proceed with the public issue. There will be a no penalty, and okay, what is it? Penalty and Madhav Casting. Why, sir? Because in your prospectus you are saying, people, that you are listed in 3 stock exchanges, but you got approval only from a couple of them. Then what about the 1 more? You did not get approval at all. Then how can you go for listing? It is a breach of, people, section 40. Yes, sorry. Next one, Rig Exploration and Refinery Limited decided to raise capital through issue of shelf prospectus. Company secretary explains the requirement to board that RERL shall be required to file an information memorandum. What is the format of information memorandum? Which form you will file? PAS 2 with the registrar. Within how many days you have to file information memorandum? 1 month prior to the issue of a second or subsequent offer. So the right answer will be 1 month. Modern Furniture decided to raise capital by issue for which prospectus need to be issued. The copy of prospectus submitted with the registrar for filing need to be duly signed by prospectus, people, section 26. What does it say? The prospectus has to be signed by, people, every director and proposed directors. Correct? Every director and proposed directors. Next one, people. Explain various instances which makes the allotment. Every director or proposed director means what, people? If your company has 5 directors, everyone has to sign, not 1 or 2. Explain various instances which makes the allotment of securities as irregular allotment under the Companies Act 2013. People, see, when we are reading allotment of securities, they are telling you under various sections they have given, if at all you do this, it is considered as irregular allotment. If you look at this question, this answer is not there in our, content, but it is only there in the question and answer. Such type of questions has also of late been, it's been started to ask people, so no and go. That's why I started taking up these questions as a separate session, which I generally used to do it inside the class. Now I am trying to do it as a separate question because this is not there in our content, the syllabus content, but in the questions it is there, and they are asking it off late. So no it can go. So what is that? So if at all in these many sections, people, if at all you have made an allotment, then the law is telling you, people, it will be considered as an irregular allotment in these scenarios. Now what is an irregular allotment? First one, people, where a company does not issue a prospectus in a public offer as required by section 23. That means what? You are doing a public offer, but you have not given prospectus. Any allotment made will be considered as irregular allotment. Second one, where the prospectus issued by the company does not include any of the matters required to be stated as per section 26(1). So what are the, people? You need to clearly say no, that nothing given in the prospectus. We have complied with all the provisions of SEBI Act, SCRA Act. You clearly give no in your prospectus. So you should have completely disclosed everything. If you have not disclosed anything, people, then it will be considered as what, people? Irregular allotment. Next one, where the prospectus has not been filed with the registrar. Remember, people, before you give it to the public, you have to first file your prospectus with the registrar. The prospectus will be valid for a period of 90 days, if you remember. So if you do not give it to the registrar, it is considered as irregular allotment. The minimum subscription as specified in the prospectus. Technically, you should you should clearly specify what is a minimum subscription. If the minimum subscription is not met, we will consider the allotment as irregular. What is the minimum subscription? According to SEBI, it is 90% of your offer. The minimum amount receivable on application is less than 25% of the nominal value of the securities. That means what? A minimum application, people, whenever you guys should have seen, no, application money, allotment money, first call, second call, your minimum application money should not be less than 25%. If it is less than 25%, people, it will be considered as irregular allotment. In case of public issue, approval for listing has not been obtained from one or more recognized stock exchanges. We just saw an MCQ. So if stock exchanges has not given you approval, people, then it will not be considered as a right allotment. It will be a irregular allotment. Important, remember and go. What is a shelf prospectus? State the important provisions with regards to the shelf prospectus. Shelf prospectus is a prospectus where if you want to do multiple offers by filing one prospectus, that is only called as what, people? Shelf prospectus. Using shelf prospectus, you can make n number of allotments up to a period of 1 year starting from the day of first offer. When you make the first offer, from that day, the prospectus will be valid for a period of 1 year. Using this, you can make n number of offers. And remember, people, shelf prospectus validity is 1 year. Whenever you go for a subsequent offer, you need to give a additional document. That additional document will be called as what, people? Information memorandum. Information memorandum will just give the details about what? Any financial change in any financial position of the company or any new charges created on the company, as the case may be. Yeah, it is given in the form PAS2. It is filed with the registrar. Next one, the Board of Directors of Chandra Mechanical Toys Limited proposes to issue a prospectus inviting offers from public for subscribing to the equity shares of the company. State the reports which shall be included in the prospectus for the purpose of providing financial information. Technically, people, the SEBI will tell us what are the details to be included. They will propose central government, and those are the details we need to include in the prospectus. But as of now, SEBI has not prescribed anything. Until SEBI does not prescribe anything, people, whatever is given in SEBI Act, we will disclose that only with regards to financial information. Not only that, we also need to give a declaration that we have not done any non-compliance with SEBI Act, SCRA Act with regards to this public offer. We need to give a declaration. Unique Builders Limited decides to pay 2.5% of the value of debentures as underwriting commission to the underwriters, but the articles of association only authorize 2% underwriting commission. The company further decides to pay the underwriting commission in the form of flats. Examine the validity of the above arrangement under the provision of Companies Act. This part is very, very important. First thing, people, as per section 40, what is the maximum commission we can pay? The maximum we can pay for shares is 5%, for debentures it is 2.5%, or whatever is given in articles, whichever is lesser. In our case, people, our articles, if it is giving lesser number, here it says only 2%. The maximum we can give as an underwriting commission cannot go beyond 2%. And not only that, people, remember, we can give the commission, people, in the form of cash, in the form of kind, everything is allowed. That is more important, no and go. Everything is allowed. So can I pay it in kind? As a flat, can I give? Absolutely fine, you can give it. We don't have a problem. Clear? Next one. PQR Bakers Limited wants to raise funds for its upcoming project. Accordingly, it has issued private placement offer letters for issuing equity shares to 55%, out of which 4 are qualified institutional buyers and remaining are individuals. Before the completion of allotment of equity shares under this offer letter, company issued another private placement offer letter to another 155% in their individual names for issue of its debentures. Being a public company, is it possible for PQR Bakers Limited to issue securities under a private placement offer? First one. Can they do? Public company can also do, people. Always, people, in exam, remember, they would have asked multiple questions. Open your eyes and carefully see. That's your first question. Can a public company do private placement? Yes. Even a private company can do, and a public company can also do. By doing so, whether the company is in compliance with the provisions relating to the private placement, or should these offer be treated as public offer? Remember, people, because the number of people is within 200, the maximum private placement you can do in a financial year per security, people, is up to 200 people. Here we have only done for what? 55 they have given. Even in that 4 are QIB. QIB you will not count at all. So technically I have done only for 51 people, which is well within 200 limit, and hence I can go for it, and it will be considered as private placement only, people, and not public offer. Next one. What if the offer for debentures is given under? What if the offer for debentures is given after allotment of equity, but within the same financial year? Remember, people, you cannot run two same private placements. I mean, you cannot run two private placements simultaneously. After the equity allotment is done, people, you can do debentures ka private placement, but before allotment of equity, you cannot run the private placement offer of debentures. Remember and go, exam point of view, very important. That's my answer. So you should write conclusion 1, conclusion 2, conclusion 3. Remember, very important. How does a Companies Act regulate and restrict the following matters in respect of a company going for public issue? Minimum amount stated in the prospectus, application money. This is what, people, 90%, this is what, people, 25%. Correct? Examine the validity of the following statement with reference to the provisions of Companies Act. The articles of association of X Limited contain a provision that the underwriting commission may be paid up to 4% of the issue price of the shares. However, the board of directors have decided to pay the underwriting commission of 5% to deal and company units. Okay. Article says 4, they want to pay 5. Possible or not possible? You can never go beyond what is given in your articles of association. Clear? Okay, let us do this one particular topic and then we can go for a break. Share capital and debentures. Mr. Bahu has received a notice from Mahishmati Private Limited on 2nd March 2024 intimating that Mr. Bali has submitted a transfer deed duly signed by him for transfer of 1000 partly paid shares in his name, Mr. Bahu transferee must raise his objection to the proposed transfer of partly shares latest by people. Whenever partly paid share, the company has to confirm with the transferee in form SH5. These are partly paid shares. Are you aware of it? You need to write back your consent people within a period of 2 weeks. If you do not reply people, it will be considered as deemed approval. We have given the request on people 2nd March 2024. Don't count second, count from third. So people 14 days, technically 2 weeks means, and hence people it will be 17th March. See, Section 67 of Companies Act impose a restriction on public company from giving any financial assistance. Technically, this is fine, people. I'll definitely not stress on fines part. I know most of you will leave and go, but I'm just not taking it up. Modern Furniture and Unlisted Company receive a request for issue of duplicate share certificates. Complete documents in this regard submitted with the company on 30th December 2022. Modern Furniture shall issue the duplicate share certificates by latest by when, people? You need to do it, people, within 29th March 2023. 3 months, because it's an unlisted public company. VRS company is holding 45% of total equity shares in SV Company Limited. The board of directors of SV Company Limited incorporated on 1st Jan decided to raise the share capital by issuing further equity shares. The board of directors resolved not to offer any shares to VRS on the ground that it was already holding a high percentage of the total number of shares issued by SV Company Limited. The Articles of Association of SV Company Limited provided that new shares should first be offered to the existing shareholders of the company. On March 1st, 2019, SV Company Limited offered new equity shares to all the shareholders except VRS Company Limited. Referring to the provision of Companies Act, examine the validity of the decision of the board of directors of SV Company Limited of not offering any further shares to VRS Company. People, for issue of further share capital or further issue of share capital, people, is given in section 62. Now you guys know in section 62 subsection 1 clause A, we have something called as, people, rights issue. If you are doing a rights issue, people, it's an offer given to all your existing equity shareholders. So when you are giving an offer to all your existing equity shareholders, you are not supposed to make any discrimination, people, whether someone is holding majority, someone is holding minority. You are not supposed to make any discrimination. So in the given case, just because VRS company is holding majority shares, people, you are not supposed to make any discrimination, and such thing will be considered as what, people? Invalid. So in the given case, yes, such offer or such allotment will be considered as invalid because you need to make it uniform. So it is a violation of provision. Here, the directors of Mars Motors India Limited desires to alter the capital clause of MOA. Advise them about the ways in which the said clause may be altered. Capital clause, people, section 61, you can alter capital clause by passing an ordinary resolution in 5 ways. One is, people, increase of authorized capital. Next one is consolidation and dividing them into smaller division, consolidation, dividing them into larger denomination. Basically, one of it is called a share split. And voting percentage cannot change. If it is changing, you need to take the approval from the tribunal. Conversion of stock into shares, shares into stock. The last one is, people, cancelling the shares which are not taken up or not subscribed. So this is only 5 ways of, people, altering your share capital. Whenever you are altering the share capital, you need to make sure you intimate the registrar in form SH7 within 30 days of alteration. Ramesh, a resident of New Delhi, sent a transfer deed duly signed by him as transferee and his brother Suresh as transferor for registration of transfer of shares to Rayan Entertainment Private Limited at its registered office in Mumbai. He did not receive the transfer share certificates even after the expiry of 4 months from the date of dispatch of transfer deed. Is there any liability of company and officer in default in the said matter? Yes, people, is it there? Yes, you are supposed to register the transfer, right? Your expiry of 4 months, and hence there will be penalty. Due to insufficient profits, Silver Robotics Limited is unable to redeem its existing preference shares amounting to 10 lakhs. Though as per terms of issue, they need to be redeemed within next 2 months. It did not, however, default in payment of dividend as and when it became due. What is the remedy available to the company in respect of outstanding preference shares as per the Companies Act? What is it, people? Is nothing but the case of rollover. What happens in rollover? Whenever you are not able to redeem the preference shares on time, then you have an option. What? You can call your preference shareholders for a meeting. If 3/4 in value of preference shareholders give you an approval, in such case, you can take such approval. You can also go to the tribunal. You need to get the tribunal's approval as well. So 3/4 of preference shareholders in value and the tribunal's approval. If both you guys get people, you can issue new preference shares in the place of the old shares. Remember, when you issue the new shares, the old shares are assumed to be redeemed. Remember. Trisha Data Security Limited was incorporated just a year ago with a paid up share capital of 200 crore. Within such a small period of about a year in operation, it has earned sizable profits and has topped the chart for its high employee friendly environment. The company wants to issue sweat equity shares to its employees. A close friend of the CEO of the company has told him that the company cannot issue sweat equity shares as minimum 2 years have not elapsed since the time company commenced its business. The CEO of the company has approached you to advise about the essential conditions to be fulfilled before the issue of sweat equity, especially since their company is about just a year old. That's absolutely fine, no, people. You just need to authorize it by articles. You need to pass a special resolution, and what is the maximum you can issue? 5 crore and 15% overall should not go beyond 25%. Whether you're a newly formed company, you're just 1 year old, all that is fine. You just have to do as per the registered valuer's valuation, you can do it. So the time and all is irrelevant. Walnut Foods Limited has an authorized share capital of 2 lakh equity shares of 100 each and amount of 2 crore in securities premium. The board of directors seeks your advice about the application of securities premium account for its business purposes. Please give your advice. Securities premium account can be used for what, people? For the 5 purpose: buyback, bonus, for issuing on commission, discount, writing off your preliminary expenses, issuing it as redemption, premium on redemption of preference share, as the case may be. So keeping the above in view, the Walnut should proceed to utilize the amount of securities premium like this. According to me, this answer is incomplete because the words used are, can they use it for business purpose? We need to clearly write, people, apart from the 5, the company cannot utilize that money for any other business purpose. Because it is vague, right? If you write the same thing, you guys will not get marks in your exam. OLAF Limited, a subsidiary of PQR Limited, decides to give a loan of 4 lakh to its human resource manager, Mr. Suryanarayan, who does not fall in the category of KMP and draws a salary of 40,000 per month to buy 500 partly paid up shares of 1,000 each in OLAF Limited. Examine the validity of the company's decision under the provision of Companies Act. Here, people, there are 2 irregularities. What are the 2 irregularities? The maximum loan. See, we cannot give it to directors or KMP. We can give it to any other person. Here, he is any other person, so we can give. It is not a problem. But people, the only problem here is, people, you can give up to 6 months ka salary. Here, what is this person's salary? His person's salary is 40,000. If I do it for 6 months, he is getting, people, 2,40,000 only. The company cannot give 4 lakh. And second thing, people, remember, I can only give it against fully paid up shares. This partly paid and all is not possible. So these 2 are the discrepancies which the company should keep it in mind. Shilpi Developers India Limited. Okay. Next one, people, the Shilpi Developers India Limited owned owed to Sunil 10,000. On becoming this debt payable, the company offered Sunil 100 shares of 100 each in full settlement of the debt. The said shares were allotted to Sunil as fully paid shares in the lieu of his debt. Examine the validity of this allotment in the light of provision of Companies Act. Is it possible, people? Only the thing is, people, before converting your loan into equity, at the time of taking loan itself, you should have passed a special resolution. If you had passed a special resolution at the time of taking the debt itself, people, then yes, this is valid. If at that case, no, people, that is not valid. This is very important. Yes, and there has to be valuation done by the registered valuer. Remember, these two are important. What is the provision of Companies Act 2013 relating to the appointment of the debenture trustee by a company? Whether the following can be appointed by the debenture trustee: a shareholder who has no beneficial interest. See, this is a tricky question. Beneficial owner cannot become a debenture trustee. A shareholder can become, no problem. A creditor whom the company owes 499 only. A person who has given guarantee for repayment of amount of debentures issued by the company. People, there is no value assets that is prescribed. So people, remember, if at all you are a creditor, the amount is immaterial. Guarantee, again people, the amount is immaterial. So these two people are not possible. This is possible. Hello? Mr. Nilesh has transferred 1,000 equity shares of Perfect Vision Private Limited to his sister, Ms. Mukta. The company did not register transfer of shares, also did not send a notice of refusal to Mr. Nilesh or Ms. Mukta within the prescribed period. Discuss as per the provision of Companies Act whether aggrieved party has any rights. People, private company people, what is the right I have? Within 60 days, people, I can go and appeal it to the tribunal because they have not replied. Within 60 days from me submitting, as per section 58, when the company refuses the registration of the transfer, then in such case, what we can do? We can appeal it to the tribunal, people, within a period of 60 days from the day we give our request. That's the answer. Shankar Portland Cement Limited is engaged in the manufacture of different types of cements and has got a good brand value. Over the years, it has built a good reputation, and its balance sheet as at March. Okay, the board of directors are proposing to declare a bonus issue of 1 share for every 2 shares held by the existing shareholders. The board wants to know the conditions and the manner of issuing. You can issue bonus shares, people, out of your free reserves, securities, premium account, and CRR. See what and all is there here. And they want to give what? They want to give 1 share for every 2 shares held. What is the total paid up capital, people? They have 10 lakh shares. So for every 2, I want to give 1. That means what? I want to give 5 lakh shares. Correct? And value is how much, people, into 10. I need 50 lakh rupees, people, as on today. Now, see if my free reserves have that. I have 3 crore. So, can I give it? I can give it. I don't have a problem. See, that's how you need to calculate. Hello? Possible. State the legal provision in respect of declaration of solvency. Declaration of solvency, people, whenever a company goes for a buyback, according to section 68, whenever a company goes for a buyback, the directors of the company will have to give a statement called as, people, declaration of solvency in form SH9, that in the next 1 year the company will not become insolvent. Sir, who should sign this declaration of solvency? It shall be signed by, people, at least 2 directors. If at all your company has a managing director, then 1 managing director should sign, mandatory. Yes, Sam? Okay. You can go for a break and come. We can discuss it after the break. Yes, people. Welcome back. So let's start with the next chapter, chapter 5. Varsha Limited decides to raise deposits of 20 lakhs from its members. However, it proposes to secure such deposits partially by offering a security worth 15 lakh. Which of the following options best describe such deposits? Always remember, people, if my deposits is say 20 lakh, and if per month my interest is coming to say 2 lakh, and if my total number of years, My deposits I've taken is say 3 years. So 2 into 3 is the interest, 6 lakh. So my, what do you say? The security should always be able to cover at least 26 lakh at any given point of time. Even if I fall short of 1 lakh here, I will consider such deposits as people unsecured deposits only. Good, remember and go. What is the maximum tenure for which a company can accept or renew deposits? 36 months, we know. Fin Limited is accepting deposits of various tenures from its members from time to time. The current register of deposits maintained at its registered office is complete. State the minimum period for which it should mandatorily be presented in good order. Which people? 8 years from the date of the last or the latest entry made. Correct? Done. Every company shall pay a penal rate of interest at the rate of what people? 18% per annum. If at all you fail to pay the deposits. Remember, this and dividends are the same. 18% per annum. As per the provision of Companies Act and relevant rules, an eligible company is not permitted to accept deposits, is not permitted to accept from public or renew the same deposits which is repayable on demand or less than 6 months. No. Further, the maximum period of acceptance of deposits cannot exceed 36 months. No. But for the purpose of meeting any of its short-term requirements, a company may accept deposits even earlier than 6 months, but not less than 3 months. Yeah, so 636.6. Okay. Enumerate the amount which, when received by a company in the ordinary course of business, will not be considered as deposit. So, ordinary course of business, what are all people? Any money you have received towards advance of your supply of goods and services, provided you supply within 365 days. Any amount received as an advance for immovable property, provided when you are taking the final amount, you need to adjust this amount paid. Any amount received as a security deposit for the purpose of carrying on the contract. Any amount received as an advance for long-term projects, except people immovable property. Any amount received as an advance towards consideration for providing future services in the form of warranty or maintenance contract. What is people? Something called as you say, no, washing machine warranty charges. I can take it, people, but the maximum period allowed is people 5 years or any other tenure which is generally followed in the industry, whichever is less. So generally in the industry we follow 3 years. So you can take annual maintenance charges or warranty charges not beyond 3 years. If you go beyond 3 years, it will be considered as deposit. Any amount received with the approval of sectoral regulator allowed, possible. That is your IRDA allows or your any TRI allows, as the case may be. Any amount received as an advance for subscription towards publication, whether in print media or in electronic form. So journals, magazines, if you have paid any money in advance, it will not be considered as deposit. If the amount received under A, B and D above becomes refundable due to the reason that the company extra money does not have necessary approval, the should be further expiry of 15 days from the date it becomes due for refund. At any given point of time, if you are not able to serve it or if you are not able to do it within time, they are telling you it will be treated as deposits. You will have 15 days time to refund. Okay, state the procedure to be followed by companies for acceptance of deposits from its members according to the Companies Act. What are the exemptions available to private companies? So there are two things, correct? They're asking you what are the procedure to be followed. 73(2) A to E is there. What is that? First one, you need to come up with a circular, DPT one. If you are raising it from public though, you need to publish in the newspaper also. Before giving it to the members, you need to first give it to the ROC 30 days prior. You need to create DRR. If it is secure deposits, you need to create a security, and you should have not made any default in repayment of these loans or deposits in the past. This is a procedure. Yes. Exemptions available to a private company, which are all people. If at all a private company which accepts deposits not exceeding 100% of its paid up share capital, free reserves and securities premium, If you are a startup people, up to a period of 5 years from the date of incorporation, that will a company which fulfills all these conditions. So a private company which fulfills all these conditions, people, what is that? It should not be an associate or a subsidiary of any other company. I feel from exam point of view, this is important. Remember and go. They can hide a question here. Remember and go. If the borrowings of such a company from banks or financial institutions or any body corporate is less than twice of its paid up share capital of 50 crore rupees, whichever is lower, that means what? If at all my company's paid up share capital is say 10 crore, how much is my loan? My loan is, people, let us imagine 15 crore. So how much is the twice of paid up share capital? 20 crore or 50 crore? Whichever is less, which is less, 20 crore. So my borrowing should be less than that. In my case, it is only 15 crore, so it is valid. Such a company has not defaulted in repayment of such borrowings subsisting at the time of accepting deposits. So you should have not made any default in repayments. For such private companies, people, these procedures are exempted. You can raise deposits from your members even without having to follow these procedures. Just that you need to disclose whatever is the money you have raised in the form DPT3. That's the only thing that is required. Remember this and go. That is, if you still raise money, you need to intimate it to the registrar. Explain the provisions for appointment of trustee of depositors under the Companies Act. What is that, people? A company shall have appointed at least one or more deposit trustees. A written consent shall be taken. A statement shall appear in the circular or advertisement with reasonable provenance that depositors have given their consent to the company for such appointment. So depositors should have agreed. The company shall execute a, very important, this thing should be there in your book, in your exam. The company shall execute a deposit trust deed which says what are the rights, duties, obligations of the deposit trustee. It shall be done in the format DPT2. It shall be entered at least 7 days before issuing the circular to the advertisement, whether members or public. At least 7 days prior, you should have entered into this deposit trust deed. Clear? No person, including a company that is in business of providing trusteeship services, shall be appointed. Okay. Disqualification, people, you should not be a director, KMP, any officer or an employee, or even a depositor is also disqualified. Remember, this can be asked as a question. This can be asked as a question. Important exam point of view. A person who is indebted, person who has taken loan, again important. Why? Remember this, as well as debentures, in both these cases, people, it does not specify how much of money. So even if you look at it, 10 rupees is also considered to be disqualified, right? Where do we get confused? We will get confused between this and the auditor provisions. You will try to get confused between this and auditors. In auditors, yes, there is value. Here there is no value. Here. Next one. A person who has any material pecuniary relationship, pecuniary means, people, monetary. So if you have any monetary relationship, you are disqualified. A person who has entered into any guarantee arrangements, that means I have not taken loan, someone has taken loan, but I have promised to repay that debt. I cannot be appointed as a deposit trustee. A person who is related to any person specified in director, KMP, officer, employee. I cannot be even their relative. All these people are disqualified. Sir, can we remove the deposit trustee? Is it possible? They are telling you to remove people. One is very important condition. What is that? If you want to remove a debenture trustee, you need to take the debenture holder's approval. But if you want to remove the deposit trustee, you need to conduct a board meeting and all the directors present have to approve the same. You need to take the consent from all the directors present. And not only that, people, you need to have, if your company has an independent director, at least one independent director should be present in such a meeting. Exam point of view, this point is very important, no and go. What are the provisions relating to credit rating which an eligible company must follow it? Generally, people, whenever a company is raising deposits from public, then credit rating becomes mandatory. The credit rating should be obtained from any of the recognized registered credit rating agencies. It should not be less than or it should not be below what is prescribed by RBI for accepting FDs, for NBFCs. Whatever is the minimum grading, it should not be less than that. And you have to take credit rating for the entire tenure of your deposits. If it is say 2 years, for entire 2 years you have to take the deposits. I mean, you need to take the credit rating and you need to disclose it to the registrar every year until the tenure of your deposits. Remember and go. Discuss the following situations in light of deposit provisions. What? Samit, one of the directors of Zar Technology Private Limited, a startup company, requested his close friend Ritesh to lend money 30 lakhs in a single tranche by way of convertible note, repayable within 6 years. Is it a deposit? Convertible note, people, if you are a registered startup, condition 1 satisfied, and if you are bringing in at least 25 lakh rupees, condition 2 satisfied, it should have been brought in a single transaction. You are not supposed to do EMIs. The third condition satisfied. Fourth one, either it should be repayable within 10 years or convertible within 10 years. Here it is 6 years. The fourth condition is also satisfied, and hence the money brought in by this person will not be considered as deposit. Next one, Polestar Traders Limited received a loan of 30 lakh from Rachna, who is one of the directors. Is it deposit? It will not be considered as deposit provided Rachna gives a declaration that the money has been given from her own funds and not from any borrowed funds, and such declaration should also be disclosed in the director's report, and such amount should also be mentioned in the financial statements. City Bakers Limited failed to repay deposits of 50 crore and interest due thereon even after the extended time granted by the tribunal. Is the company or Swati, its offices in default, liable to any penalty? Penalty will definitely be there, people. Shringar, they're asking about penalty provision. Shringar Ready-Made Garments Limited wants to accept deposits of rupees 50 lakh. What is the penalty done? Which shall be minimum 1 crore or twice of the amount involved in the deposits. Up to 10 crore, whichever is less. That's the penalty. Correct, huh? If I'm not wrong, that's a penalty. Rupees 1 crore or twice amount of deposits accepted, whichever is lower, but which may extend it to 10 crore. Okay. Next one, is it in order for Diamond Housing Finance Limited to accept and renew deposits from the public from time to time? People, housing finance companies, NBFCs are all exempted from following section 73, if you remember. So housing finance company, they are free, people, absolutely no problem. They are free to accept deposits from public from time to time because these provisions itself will not apply to them. Correct? So it is exempted. Okay, ABC Limited, having a net worth of 120 crore, wants to accept deposits from its members. The directors of the company have approached you to advise them as to what special care has to be taken while accepting deposits from the members in case their company falls within the category of eligible company. So you are an eligible company, you are having a net worth of 120 crore, correct? You can accept deposits because at least 100 crore or more. So 120 you can accept that, but they're taking from members, not from public. The directors approached you to advise them what special care has to be taken. Only thing is what, people, if you're an eligible company, what is the maximum you can accept deposits from members? It should not be more than 10% of your paid up share capital, free reserve, securities premium. From public you can take 25%. That's the only thing. Define the term deposits under the provisions and comment relating the following. 5 lakh raised by Rishi Confectionaries Limited through issue of non-convertible debentures, no charge. But it is listed. Of course, it is not considered as a debentures. If any one condition also not satisfied, meaning what? If it is convertible but listed, it is considered as deposit. Non-convertible, listed but secure, it will be a deposit. If these three conditions also not satisfied, then it is not a deposit. 2 lakh received by Raja Yarns Limited from its employee, Mr. Tarun, who draws an annual salary of 1 lakh 50 as a non-interest bearing. Is it a deposit, people? Hello? People, annual salary is 1 lakh 50, but you have taken 2 lakh. It will be treated as deposit. 3 lakh received by a private company from one of the relatives of a director. The said relative has furnished a declaration that the amount was received by him from his mother as a gift. 3 lakh received from a private company from one of the relatives of a director. Remember, if you are a public company, only directors can give. If you are a private company, even the relatives of a director can also give. It will not be treated as deposit. But what is one confusing question that they have put here? The relative has given a declaration that I am giving this money out of the money that was given to me as a gift by my mother. I am giving that money to you. Is it okay? People, is it okay? What do you think? Of course, people, you would have said that it is not okay. The answer is it's okay, people. Why? Logically think, people. I am not borrowing. Gift is mine only. After the gift is done, that money becomes mine only, no? So it is my money only. So in the given case, is it a what is the deposit or not? It is not considered as a deposit. Remember and go. Clear? Hello? State with reasons whether the following statements are true or false. ABC Private Limited may accept deposits from its members to the extent of 50 lakh if the aggregate of paid up share capital, free reserve and security premium account is 50 lakh. Yes, people, a private company can accept up to 100% of the paid up share capital, free reserves and securities premium. It is allowed. They have exemption. A government company which is eligible to accept deposits under Section 76 of Companies Act cannot accept deposits from public exceeding 25%. It is false. Why, people? They can accept up to 35%. So 25% is false. Answer the following. Prayas Electricals Limited, having a paid up share capital of 1 crore, availed a term loan of 10 lakh from Beta Bank Limited to purchase electricals. Mr. Sambhav, one of the directors of the company, the opinion that it shall be considered as deposit. No, people, this will come under any money taken from a banking company. It will not be considered as deposit. Eklavya Publishing Company Limited, facing acute cash crunch, wants to utilize a portion of its deposit repayment reserve to pay off its short-term creditors. Can they do it, people? Definitely no. DRR cannot be used for any purpose other than repayment of your deposits. Sanjeev is a shareholder in Utsha Textiles Private Limited, holding 10,000 shares of 10 each. His wife Sneha and his 3 sons Ayush, Pranav and Himanshu are also shareholders in the company, holding 1,000 shares each. In response to the invitation from the company inviting deposits from its members, Sanjeev wants to deposit 1 lakh for 36 months jointly with his wife and 3 sons. Whether Utsha Textiles Private Limited can accede to the request of Sanjeev and accept deposits jointly in 5 names, since all the depositors are shareholders of the company, can they do it? Possible? Remember, people, joint depositor cannot be more than 3. In the given case, I think him, wife and 3 sons, it will become 5. So not possible. The maximum joint depositors cannot exceed 3. Shubhra Chemicals Private Limited, not a startup, is desirous of accepting deposits from its members amounting to 200% of its paid up share capital, free reserve, securities premium. What are the conditions to be fulfilled? Same thing, people, whatever we saw up. You should not be an associate or a subsidiary company. Your borrowing should not be more than twice of your paid up share capital or 50 crore rupees, whichever is less. You should have not made default in repaying of any of the deposits accepted. If you satisfy any of these people, you can accept money more than 100%, absolutely fine. Then let's start our next chapter. What now? Registration of charges. Hey, I hope you guys are understanding something. See, just relax, sit back. With me, you should also be able to tell the provisions. I'm only telling the keywords that is very, very important for you from the exam point of view. Also, I'm simply not dragging it. You should also have a satisfaction that, okay, this was a question that was there in the textbook, we covered. Yeah, so when you're going before the exam, that's the easiest thing that we can do, correct? Any person acquiring property on which charge is registered under Section 77 shall be deemed to have notice of the charge from the date of such registration, correct? It can also be considered as constructive notice also, or it can also be answered under section 80 also. Once the charge is registered, it will be considered as what people are deemed a public notice. A charge was created by this limited on its office premises to secure a term loan of 1 crore availed from NextGen Commercials Bank Limited through an instrument of charge executed by both the parties on a 16th Feb 2023. This is when it was executed, important date. Inadvertently, the company could not get the charge registered with the concerned ROC within its first statutory period. What is the first statutory period? You need to register the charge within 30 days. And the default was made known to it by the bank, by the lending banker with a stern warning to take immediate steps for rectification. The latest date within which the company must register the charge with the ROC so as to avoid paying ad valorem fees for registration of the charges. What people? First, if you fail to do it within 30 days, you will be given extra 30 days. If you fail within this also, you will get last another 60 days. This is normal fees. This is additional fees. This is ad valorem fees. So they're telling you, we missed this. We do not want to go here. Then this is what is your scenario. So within 60 days from the date of, entering the charge, from the date of creation of the charge, within 60 days, people, what I have to do? I have to register the charge by paying additional fees. Correct? So in the given case, calculate 16th Feb 2023, leave 16 from 17, count 60 days. And that will be what people? 17th April 2023 is the answer. The instrument creating a charge or modification thereon shall be preserved for a period of dash years from the date of satisfaction of charge by the company. 8 years. Remember, instrument is 8 years. Register of charges, permanent. An interest of lien created on the property will be called as what people charge. Who cannot inspect the register of charges and instrument of charges during the business hours? Instead of who cannot, I'll say who can. Who can people? Creditors and members, free of cost, every other person by paying such fees. So members can inspect, creditors can inspect. Persons other than members and creditors cannot inspect. That's why they're telling you, who cannot. Yeah. Technically, others can inspect but by paying some prescribed fees. They can inspect without paying any fees. Yeah. However, a copy of an instrument evidencing creation of charge and required to be filed with the registrar be verified. Verification, what people? Depends upon where the property is. If the property is within India or outside India. If the property is outside India, people, it can be verified by, first one is under the seal of the company. If not by seal, then people by any director or any CS of the company. Sir, or if not director, if not CS also, then people, any authorized officer of the charge holder, that means of a bank. That's the third condition. So seal, director or CS or the authorized officer of the charge holder. Even if that is not the case, then people are under the hand of some person other than the company who is interested in the mortgage or charge. That means what? It can be like a surety. It can be like a guarantee. So the borrower also is not certifying. The creditor is also not certifying. A guarantee can certify maybe. So that is this. Sir, what if the property is in India? Then people, the last condition will not come. The rest and all is same. Correct? What is a floating charge? A charge which is created on the asset which is not fixed is called as what people floating charge. In this case, what happens people? The company can freely, sell the property without having to ask the approval from the lender. Yes, and yeah, correct. What are the examples people? Stock in trade, raw materials, debtors, as the case may be. When does the floating charge gets crystallized? When the creditor enforces a security, when the company goes into liquidation, when the company ceases to carry on the business, as the case may be. Define the term charge and also explain what is the punishment for default with respect to the registration of charge. I'm just leaving this punishment. I'm just leaving it. Renuka Soaps and Detergents Limited realized on 2nd May 2024, they realized on 2nd May that the particulars of charge created on, they have created on 10th March it seems, in favor of Sankalp, were not registered with ROC. What procedure should the company follow to get the charge registered? Would the procedure be different if the company realized its mistake of not registering the charge on 7th June 2024 instead of 2nd May? Explain with reference to the Companies Act. 10th March people, 10th March to 10th April, let us imagine 30 days. Yeah. 10th April to 10th May will be 60 days. Here you have realized on 2nd May, there is nothing that you will lose people, you can still go and register by paying additional fees. Instead of 2nd May, if you realize on 7th June, then what will happen? Now try to calculate. 10th March to 10th April, 30 days. 10th May, 60 days. Say 10th June. Oh, like that we cannot calculate here. We'll have to take the number of days into picture. You need to calculate whether it is going beyond 120 days. We need to count it there. Yes, that is something we need to check. Yeah. When is it coming for 120 days period? That's all. They're telling ad valorem fees. So it is still within. Correct? I'm just taking roughly, it comes to around say 9th June, something like that. You just have to calculate. How will you calculate people? Generally, I'm saying it is created on 10th March. So in March, exclude 10 days. Take 21 days. Yeah. March is 31. April is 30. May is again 31. One second, wait. How do you guys do it in the exam? This is one thing which I'm bad at even from the day of school also. So I'm taking the help of calendar. Yeah. So I believe you guys know this now. Jan, Feb, March, April, May. So everything that comes on the top will be considered as 31. The bottom will always be 30. Correct? 31, 30. But yes, before going for the exam, check and go. So March, April is 30. May is 31. Now, when did they realize? In our case, 7th June. So, 7th June, take this as 7. Add everything. How much is it coming to? This is 50. This is plus 30, 80, 81, 82, 7, 89. So, it is definitely within time. We don't have a problem. Maximum, we have 120 days, no? So, it's absolutely fine, no problem. So, by paying ad valorem fees, it is still possible. Mr. Antriksh purchased a commercial property in Delhi belonging to NRT Limited after entering into an agreement with the company. See, in exam, no, please show calculations like this. You getting an extra mark is always high. There are high chances that you will be given an extra mark. Yeah. So imagine if the valuer is getting confused to give you 3 or 4. There are high chances that they will give you 4. Yeah. Okay. And the company expressed its inability to get the title deed transferred in Antriksh's name, contending that he ought to have the knowledge of charge created on the property of the company. Explain whether the contention of NRT Limited is correct. People, just now we saw in MCQ, section 80, constructive notice. The moment the company has registered the charge people, the company will not again give you a separate disclosure that on this property there is a charge. It is your duty when when you're acting with the company, it is your duty to know that there is a charge registered. It is your duty to check the documents. If you don't check, we don't care. So we assume that you have checked all the documents. Remember? Clear? Now, section 18, deemed public notice. A company is required to keep a register of charges at its registered office. Considering this statement, mention the provision of Companies Act in respect of keeping of register of charges. Register of charges maintained in the form CHG 7. Entry shall be authenticated by a director or a CS or such other person authorized by the board. And what else? The entries shall be made forthwith, as immediately as possible. It shall be maintained permanently. Register of charges. Who can inspect the register of members? As I told you, creator or member without paying any fees. Any other person by paying such prescribed fees. Yeah. ABC Limited created a charge in favor of OK Bank, which was duly registered. Later on, the bank enhanced the facility by another 20 crore. Due to inadvertence, the modification in the original charge was not registered. Advise the company as to the course of action to be pursued in this regard. Yes, sir. So, what is the scenario, people? Nothing but people, section 87. It says you need to file one form called as people form CHG8. Condonation of delay with the central government. Whenever you have made such thing, go and ask an excuse. If omission or misstatement in any of these things, you can go and ask for an excuse. If the central government is satisfied, they may allow you to register the modification even beyond the time. Okay, Ranjit acquired a property from PQR Limited which was mortgaged to Pyramid Bank. He settled the dues to Pyramid Bank in full, and the same was registered with the sub-registrar who noted that the mortgage has been settled. But neither the company nor Pyramid Bank filed particulars of satisfaction of charge with the ROC. Can Ranjit approach the ROC and seek any relief in this regard? Discuss this matter in the light of provision of Companies Act. Always remember, people, Ranjit can intimate to the registrar, section 83. ROC, even if the charge holder or the creator of charge, even if none of them intimate, but if the registrar gets to know that that particular charge is settled, the registrar, after due verification, people, under section 83, on its own, can also issue a memorandum of satisfaction of charge for both the parties. And in its book, the registrar can make an entry that this particular charge is satisfied. Yeah, section 83 and the memorandum of satisfaction of the charge issued by the registrar to both the parties will be in CHG 5. Yes, sir. That's your charge chapter. Hello, just 1 second. Yes, people. Next chapter. So, AGM of Green Limited was held on 31st August. Suppose the chairman of the company after 2 days of AGM went abroad for next 31 days due to the unavailability of the chairman within the time period prescribed for submission of copy of report of AGM with the registrar. The report as required was signed by 2 directors of the company, one of which was an additional director of the company. Comment on the signing of this report of AGM. Always remember, people, if chairman is unable to sign, then in such case what should we do? We need to get the signature from at least 2 directors, one of whom shall be a managing director, and CS, if it is there, CS also has to sign. That is the answer. Basically, section 121, report on AGM. AGM shall be called by giving 21 clear days notice. However, it can be called by giving shorter notice if members are entitled to vote at that meeting, give their consent in writing. How many people? 95%. Which among the following companies is not required to provide its members the facility to exercise right to vote by electronic mode? So, e-voting, for whom is it not required? B Limited, whose equity shares are listed. A Limited, whose equity shares are listed. C Limited, whose preference is listed, whose equity and preference is listed. Of course, preference is listed. In a general meeting of Alpha Software Limited, the chairman directed to exclude certain matters detrimental to the interest of the company from the minutes. Mukesh, a shareholder, contended that the minutes of the meeting must contain fair and correct summary of the proceedings thereat. Decide whether the contention of Mukesh is maintainable under the provision of Companies Act 2013. Yes, people, section 118 says, minutes of the meeting, the chairman can remove 3 things from his, minutes. What are the 3 things, people? 1, people, anything which causes defamatory of any person, that means you are abusing or something like that. Something which is irrelevant or immaterial, you ask someone, did you have your lunch? It need not be there. something which is detrimental to the company, meaning if this is written, the companies, there will be a damage. Those things can be eliminated. A general meeting was scheduled to be held on Friday, 15th April 2024 at 3 p.m. Just 1 second, people.
Hello, sir. ನಾನು ಇಲ್ಲೇ ಇಲ್ಲಿ ರೆಕಾರ್ಡಿಂಗ್ ಎಲ್ಲ ಇದ್ದೆ. ನಾನು ಅಂದರೆ ಐ ಡಿಡ್ ನಾಟ್ ಕಂಪ್ಲೀಟ್ಲಿ ಸಿಟ್ ಆನ್ ಇಟ್. ನೀವೆಷ್ಟೊತ್ತವರೆಗೂ ಇರ್ತೀರಾ? ಹಾಂ, ಸರಿ ಸರಿ, ಓಕೆ ಓಕೆ. ಓಕೆ ಓಕೆ ಓಕೆ, ಶೋರ್ ಸರ್, ಶೋರ್. ಡನ್ ಸರ್, ಓಕೆ, ಶೋರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
As per the notice, the members who are unable to attend a meeting in person can appoint a proxy, and the proxy forms duly filled should be sent to the company so as to reach at least 48 hours before the meeting. Mr. X, a member of the company, appoints Mr. Y as his proxy, and the proxy form dated 9th April 2024 was deposited by Mr. Y with the company at its registered office on 11th April 2024. Similarly, another member, Mr. W, also gives two proxies to two individuals, M and N. In the case of M, the proxy dated 12th April was deposited with the company on the same day, and the proxy form in favor of N was deposited on 14th April 2024. All the proxies, namely Y, M and N, were present before the meeting. According to the provision of Companies Act, who would be the person allowed to represent the proxy? Yes, people. In this case, what happened? There are two people, right? For the proxy form to be valid, you need to submit at least 48 hours prior. And remember, if at all you have submitted two proxy forms, whatever is submitted latest will prevail. However, provided you need to submit it at least 48 hours prior. So in the first case, I don't think we have any problem. In case member X, the proxy Y, will be permitted to attend, there is no problem as such. However, in the case of W, there are two people. I think N has been given on 14th, whereas the meeting itself is on 15th. So 14th will be invalid and 12th will be considered as valid. So M is valid, N is invalid. Mr. H Mechanics Company Limited served the notice of general meeting upon its shareholders. The notice stated that the issue of sweat equity shares would be considered at such meeting. Mr. A, a shareholder of the MH Mechanics Company Limited, the notice stated that the issue of sweat equity shares would be considered at such meeting. Mr. A, a shareholder of the MH Mechanics Company Limited, complains that the issue of sweat equity shares was not specified fully in the notice. Is the notice issued by MH Mechanics Company Limited regarding issue of sweat equity shares valid according to the provision of Companies Act? What are the people? The notice said that the issue of sweat equity shares will be considered at such meeting. Mr. A, a shareholder of MH complained the issue of sweat equity shares was not specified fully in the notice. Correct, no people? Explanatory statement clearly tells people you need to disclose every particular information. Which shareholder? Why are we giving him sweat equity? What is the price? What did he give? What is the valuation? We need all these details. It has to be disclosed in our explanatory statement. If you do not disclose, then how do we make our opinion? That is point one. Point two, we need to give any financial interest. We have no direct and indirect. One is in our company, one is in the other company, right? So we need to give all this information. If it is not given, of course, it will be considered as invalid. So the contention is correct. Tulip Gardens Limited maintains its register of members at its registered office in Mumbai. A group of members residing in Kolkata wants to keep the register of members at Kolkata. Can you keep it now? Keeping in view the provisions of Companies Act, explain whether Tulip Gardens Limited can keep the registers and returns at Kolkata. Provision people, section 94 says, place of keeping. Where can I keep? I have to keep it in the registered office. Can I keep it elsewhere? Possible, provided people, I need to pass a special resolution. And from Kolkata, more than 1/10 of the total number of members, if they are residing in Kolkata, I can keep it in Kolkata. So special and more than. Whether Mr. Rich, a director holding only 400 shares of worth 4,000, has the right to inspect the register of members. Even if you have one share, you can inspect. So how much you hold is irrelevant. Done. The board of directors of Shreya Transporters and Logistics Limited called an EGM upon the requisition of members. However, the meeting was adjourned on the ground that the quorum was not present at the meeting. Advise the company. Always remember, people, if it is a requisitioned meeting, members only ask for it, and if on that day if the quorum is not present, the meeting will stand cancelled and there will be no adjournment. Zora Garments Limited served the notice of general meeting upon its members. The notice stated that a resolution to increase the share capital of the company would be considered at such meeting. Roshni, a shareholder of the company, complained that the amount of proposed increase was not specified in the notice. Is the notice valid? Same thing only, no, people. Sweat equity. I have to disclose everything about the director's interest, KMP interest, relatives in my company, in the other company, 2%. Everything has to be disclosed. Examine the validity of the following decisions of the board of directors with reference to the provision of Companies Act. In an AGM of a company having share capital, 80 members present in person or by proxy holding more than 1/10 of the total voting power demand for a poll. The chairman of the meeting rejected the request on the ground that only the members present in person can demand. People, poll. Only person can demand, proxies can also demand. Proxies can also demand. Okay. How many people should demand for it? Members holding 1/10 of the total voting power or members holding 5 lakh paid up value. So either of them can demand. In an AGM during the process of poll, the members who earlier demanded for the poll want to withdraw. The chairman of the meeting rejected the request on the ground that once the poll started, it cannot be withdrawn. Can we withdraw, people? Absolutely fine, you can withdraw the poll. The people who made it only can withdraw it. Surya, a shareholder, gives a notice for inspecting proxies 5 days before the meeting is scheduled and approaches the company 2 days before the scheduled meeting for inspecting the same. What is the legal position? People, proxy forms will be open for inspection. You need to give at least, the a 3-day notice, and the inspection will start 24 hours prior to the date of the meeting. Imagine if the date of the meeting is 24th September 2026. The proxy inspection will start from 23rd September 26. If the meeting starts at 9 a.m., it will start at 9 a.m. on 23rd September. It will end with AGM. So if AGM ends on 24th September 12, so at 12 it will end. So if he has come 3 days prior, 2 days prior, it will not bind the company. He needs to come 24 hours prior to the date of the meeting. There are certain entities to which the company's SBO rules are not applicable. List them. Who are the people? IPF and the holding company, where if you are your intermediate company, if it has already reported, then again you need not do it. Something like this, A, B, C. If B has already done or A has already done, B again need not do. They have already reported on behalf of everyone. The central government, state government or local authority, if they are holding shares, SBO not applicable. And reporting company, body corporate, any internal, basically, what is that? SEBI registered, AIFs, venture capitals, mutual funds, REITs, InvITs, not applicable. That is what they are telling. Okay, Infotech Limited was incorporated on 1st April 2022. No general meeting of the company has been held till 30th April 2024. Discuss the provision of the Companies Act regarding the time limit for holding the first AGM of the company and the power of registrar to grant extension for the first AGM. First AGM, people, within 9 months from the closure of financial year, and if you are not able to conduct your first AGM, then you can apply for extension. Remember, for first AGM, no ROC extension will apply. That is my answer. The Articles of Association of DJA Water Tanks Limited require the personal presence of 7 members to constitute quorum. The company has 965 members as on the date of the meeting. The following persons were present. So whenever AOA and Companies Act, 5 or 7, whichever is higher, so this will become my quorum. A is the representative of Governor of Uttar Pradesh, counted in quorum. Preference shareholders not counted. D is representing Y Limited and Z Limited, they are counted as 2. E, F, G and H are proxies, not counted. So is the quorum present? Absolutely not. Only 3 people are present. Okay. What do you mean by proxy? Explain the provision relating to appointment of proxy. Proxy people, when you are not able to personally, a person entitled to attend the meeting and vote, when he is not able to attend the meeting, can appoint someone else to represent himself in the meeting, and such person will be considered as proxy. Proxy to be valid, you need to appoint 48 hours prior to the meeting, and proxy cannot speak, proxy can vote on poll, proxy cannot vote on show of hands, proxy is not counted for the purpose of quorum. The maximum number of people the proxy can represent is 50, not more than 50 members, and not more than 10% of the paid up share capital. If you want to represent more than 10%, then you can only represent on behalf of one person. All these are the proxy provisions. Supermart Limited called its AGM in order to lay down the financial statements for approval of shareholders. Due to want of quorum, the meeting was cancelled. The directors did not file the annual returns with the registrars. The directors were of the opinion that the time for filing of returns within 60 days from the date of AGM would not apply, as AGM was cancelled. Has the company contravened the provision of Companies Act? If the company has contravened the provision of the Act, how will it be penalized? What are those people? If at all you have not conducted AGM, people, you need to still file annual return within 60 days from the due date of AGM. In our case, if you are not able to conduct the AGM, people, you need to still you still need to file annual return, people, within 60 days from the due date. So here I am not exempted, I have to still file along with the reasons why we were not able to conduct the AGM. So this I need to file it with the ROC. Section 92. Madurai Bakes Limited issued a notice for holding AGM on 7 September. The notice was posted to the members on 16th August. Some members of the company alleged that the company had not complied with the provisions, referring whether the meeting has been validly called. If there is a shortfall, explain how many days does the notice fall short. Can the delay in giving notice be condoned? Remember, condone means can it be excused? No. If it's a delay, it's a delay. It's a non-compliance only. Was the meeting validly called? 7th is the AGM, people. The notice was posted on 16th. So you should not count 7th, you should not count 16th. Between these people, there should be a gap of 21 days. Now we need to count that. How do we count? In August, people, how many days are there? I think August is 31. August is 31, September is 30. Correct? So in September, we have 6 days. In August, out of 31, how many days we have to exclude? We have to exclude 16 days. No, take off 16. And how much is left? 15. 15 plus 6 people, 21 days. Correct? But unfortunately, how are they given? They are given by post. I need to add another 2 days. So there should be a clear gap of 23 days, people. Are they satisfied? No, exactly this coming now. Hello. Technically, you count like this, people. If this is complicated, easiest way, count like this. 17, 18, 19, 20, 21, 22, 23, 24, 25, 26. Count like this. 27, 28, 29, 30, 31. I believe August is 31 only, no? See, I have this problem with me. You before going, check the days and go down. Important. Now it's been long time, that's why I don't know which one and all. 31, yes, sir. So 15 plus 6, sir. So we are falling short by 2 days because if it is sent by post, I need to add another 2 days now. Correct? Hello? So, fall short by 2 days. KMN Cables Limited scheduled its AGM to be held on 15 September 2024 at 11 am. The company has 900 members on the scheduled date. So, the quorum has to be what? 5. The following persons were present. P1, P2, P3 are shareholders. P3, P4, count them as 1 and 1. P6, P7 as proxies, don't count them. Examine with reference. Now people, shareholders, I will assume at the people, assuming them to be equity shareholders. So I will count them. 3, 4, 5. 5 people are present. So if the quorum present, answer is yes. What will be the answer if P4 representing ABC Limited reads the meeting after 11:30? Remember, quorum has to be present within 30 minutes of the meeting. The meeting is at 11. So 11:30 is like 30 minutes. If not, people, quorum is not present. So the meeting will be adjourned. In lack of quorum, discuss the provisions as applicable for adjourned meeting in terms of date, time and place. If no quorum people, the meeting will be automatically adjourned to the same time next week, same place. Correct? Done. As a matter of fact, the usual time allowed for making entries in the register of members or register of debenture holders or register of other security holders is 7 days. After the board of directors or its committee grants its approval, there are certain events on the happening of which the entries can be made even after 7 days. Which are those events? Ababa. Generally, people, this is a case where if you are in the case of a company who is listed, if its promoters are taking any loan by pledging their shares, I repeat, let us imagine if I am a promoter of a company called XYZ Limited. So, I want loan. I go to ICICI Bank, I pledge my shares in XYZ company, I pledge it with ICICI and I borrow loan. Now the question is, people, the XYZ Limited, I have to intimate them. The XYZ Limited in the register of members, they have to clearly make an entry that the particular person has created a pledge in favor of ICICI Bank. Now this has to be done, people, within 15 days from such an event. Yes, sir. Understood? That is the first one. Second one is, people, same thing. Whenever I pledge it, but this time is not for me. If I am pledging it for, so I am the promoter, I am pledging the shares, but not for my company, I am pledging it for our joint venture. There is a third company. Imagine we have started a joint venture. So Maruti Suzuki is there. So Maruti company ka directors, they pledge their shares for funding in Maruti Suzuki. Some loan they want to give. So for that, if you are pledging people, even that is also okay. Same thing, within 15 days you need to make the entry. Just remember these two things and go. This is for listed companies. With a view to transact some urgent business, Ratna, Rimpi and Ratnesh Ababa, the 3 directors of Shilpakar Constructions Limited, are desirous of calling the general meeting of shareholders by giving shorter notice than 21 days clear notice. The 4th director, Nilesh, is of the opinion that such an action will attract penalty. Okay. Providence since there is a contract. The paid up share capital of the company is 30 crore divided into 3 crore shares. Keeping in view the applicable provision, discuss relating the possibility of calling a general meeting. Possible, people, see, they have given us calling the general meeting. We don't know AGM or EGM. That's why we have to write both. If it's AGM, people, then I need to get a prior approval from 95% of the members entitled to vote. That means I'm asking in number of people. If they agree, I don't have a problem. I can even conduct the meeting by giving 2 days notice. 5 days notice is also okay. So in the case of any other general meeting, I need to have 2 things. Majority in number and 95% in value. If it is any other general meeting, so I write this and our solution. So yes, it is possible, provided I get approval from, if it is a AGM, 95% of the members. If it is any other general meeting, then 95 majority in number and 95% in value. Mirage Sugar Mills Limited held its AGM on September 15, 2024. The meeting was presided over by Mr. Venkat, the chairman of the board of the company. On September 17, 2024, Mr. Venkat, the chairman, without signing the minutes of the meeting, left India to look after his father who fell sick in London. Referring to the provision of Companies Act, examine the manner in which the minutes of the above meeting are to be signed in the absence of Mr. Venkat and by whom. What happens, people, if it's a general meeting, if the chairman of the current meeting is unavailable, then the board of directors will authorize one amongst them to sign the minutes of the meeting on behalf of the chairman. Okay. Next one. The paid up share capital of Disha Home Appliance Limited is 8 crore divided into 80 lakh shares of 10 each. The directors of the company would like to know the circumstances under which the annual return of the company should be required to be certified by company secretary in practice. If you are a listed company, if you are having a paid up share capital of 10 crore or more, or if you are a company who is having a turnover of 50 crore or more, you need to get your annual return certified by a practicing company secretary in form MGT 8. Prince Auto Parts Limited, a listed company, has recently concluded its AGM. As a statutory requirement, it is obligatory on its part to file with the jurisdictional ROC a copy of the report on its AGM. State within how much time it is required to be filed. It is to be filed within 30 days. In case Prince Auto Parts fails to file a report on its AGM within specified time, state the penalty, to which penalty, people. I'll just leave penalties part. Chalo, let's start the next chapter. Chapter 8, people. Dividends. When the dividend is declared at the AGM of the company, it is known as final dividend. Amount to be transferred to reserves out of the profits before any declaration of dividend. There is no statutory requirement to transfer any percentage to reserve. You can completely use the entire money to pay dividends. D. The board of directors of Vidyut Limited are contemplating to declare interim dividend in the last week of July, but the company has incurred loss during the current financial year up to the end of June 2024. However, it is noted that during the previous 5 financial years, the company had declared dividend at the rate of so and so respectively. Advise the board as to the maximum rate at which they can declare interim dividend. Take the last 3 years. 12, 11, 10. That is how much? 33 divided by 3, 11%. The amount accumulated in the IEPF fund shall not be used for refunds. We can use reimbursement of legal expenses, class action suit. We can use grant or donation to central government for the purpose of investor education and training. Distribution of this we can use C. In case of company fails to pay declared dividends or fails to post dividend warrants within 30 days of declaration, company shall be liable to pay a simple interest at the rate of, I already told you, dividends is also 18% on rate. Deposits also 18% only. Next one, the AGM of ABC Bakers held on 30th May declared a dividend at the rate of 30% payable on its paid up equity share capital as recommended by the board. However, the company was unable to post a dividend warrant to Mr. Ranjan, an equity shareholder, up to 25th July 2024. Mr. Ranjan filed a suit against the company for the payment of dividend along with the interest rate of 20% per annum for the period of default. Decide in the light of provisions whether Mr. Ranjan would succeed. Also state the director's liability in this regard under the Act. Can I claim 20% people? Absolutely not possible. In this particular question, people try to remember the dividend. Dividend is, the penalty is important. The officer in default, every director of the company shall be punishable with imprisonment up to 2 years and a minimum fine of rupees 1,000 for every day during which such default continues. That is going to be my punishment. The board of directors of Future Fashions Limited at its meeting recommended a dividend on its paid-up equity share capital, which was later on approved by shareholders at AGM. Thereafter, the directors at another meeting of the board passed a board resolution for diverting a total dividend to be paid to the shareholders for purchase of certain short-term investments in the name of company. As a result, the dividend was paid to shareholders after 45 days. Examine the provision, state whether the Act of Directors is violation. Absolutely no, people. What should we do? There is section 124 which says whenever a dividend is paid, then what should we do? The company shall within 5 days, I need to separate it. Within 30 days, I need to pay it. Within 7 days, I need to transfer it to another account called as unpaid dividend account. So 5 days, 30 days, 7 days. Within 5 days, I have to put it into a separate account. Within 30 days from the date of declaration, I need to make the payments. If I am not able to make the payments to anyone, then within 7 days, people, I need to transfer the money into another account called as unclaimed dividend account or unpaid dividend account. So in our case, people, 45 days you have made a default, then of course will be liable. The same thing, people. Whatever the liability we saw, the same thing will apply. Every director knowingly punishable with imprisonment 2 years, 1,000 rupees, penalty 18%. Referring to the provisions of Companies Act, examine the validity of the following. The Board of Directors of ABC Tractor proposes to declare dividend rate of 20% to the equity, despite the fact that the company has defaulted in repayment of public deposits. Can we do? No. If you have meaning if at all you have made a default in repayment of deposits, people, you cannot declare dividend. Star Computers Limited declared and paid dividend in time to all its equity shareholders for the financial year 23-24, except in the following 2 cases. Sheila Bhatt, holding 250 shares, had mandated the company to directly deposit the dividend amount in their bank account. The company accordingly remitted the dividend, but the bank returned the payment on the ground that there was difference in surname of the payee in the bank records. The company, however, did not inform Ms. Sheila Bhatt about this discrepancy. Remember, people, the company will not be liable if I have followed the shareholder's mandate, but it failed, and I have to inform the shareholder whatever you told us to do, we did it. But it did not go through. I have to intimate you. If I do not intimate you, people, it is considered as non-compliance. Here we did not intimate, and hence non-compliance. So up to 2 years imprisonment, 1,000 rupees, it is as it is. Dividend amount of 50,000 was not paid to the successor of late Mr. Mohan in the view of the court order restraining the payment due to family dispute. That is okay. Due to any family dispute, people, if we have not paid, there is no problem. So due to any operation of law, if we did not make any payment, that is not our mistake. That's absolutely fine. Alpha Herbals, a Section 8 company, is planning to declare dividend in the AGM for the financial year ended 31st March 2024. Mr. Chopra is holding 800 equity shares as on the date. State whether the act of the company is according to the provision of Companies Act. Section 8 company, can you? You cannot. Simple, prohibited from declaring dividend, no, Section 8 companies. YZ Medical Instrument Limited is manufacturing company and has proposed a dividend at the rate of 10% for the year 23-24 out of the profits of the current year. The company has earned a profit of 910 crore during 23-24. The company does not intend to transfer any amount to the general reserves out of the profits. Is YZ Medical Instruments Limited allowed to do so? You are absolutely allowed, people. I told you, transfer of any money to the reserves is not mandatory. It is your choice. So if you have 910 crore, you declare how much ever you want. What is my problem? PQ Limited declared and paid 10% dividend to all its shareholders except Mr. Kumar, holding 500 equity shares, who instructed the company to deposit the dividend amount directly in his bank. The company accordingly remitted, but the bank returned the payment on the ground that the account number as given by Mr. Kumar doesn't tally with the records of the bank. The company, however, did not inform. Same thing, no? Alex Limited is facing loss in business during the financial year. In the immediate preceding 3 financial years, the company had declared 7, 11, 12 respectively. The board has decided to declare 12% interim dividend for the current financial year, at least to be par with the immediate preceding year. Is the act of the board valid? Remember people, in the current year if you have losses while you are paying interim dividends, the maximum I can declare cannot exceed the last 3 years rate. And how much is that? 7 plus 11 plus 12, 13, 20, 30%, 30 over 3, 10. The maximum I can pay is people 10% and not 12%. That's all. Okay, let us go over this chapter also. Accounts. ABC Limited has its shares listed on recognized stock exchange in India. During the current financial year ending on 31st March 2024, SEBI has found some irregularities in filings made by the company. Accordingly, SEBI proposes to take an application to the tribunal for reopening of the books of accounts of the company. You as an expert are called upon to SEBI to advise the financial year up to which we can reopen. What people, the current financial year ending is people that are in 31st March 2024. That means what? You are in the year 23-24. Don't count this year. Start counting from 20 to 23, 21, 22. Like this, you have to go to 8th year. Whichever is that 8th year that you are getting, that is the maximum you can open. You cannot go for that. Now, this is year 1, year 2. Let it go. Where the 8th comes, that will give you 2015, 2016. Here. As to the problem of Companies Act, which of the following statement is correct with respect to the surplus arising out of CSR? Basically, whatever is the money you earn from CSR, you have to put it back into CSR only. You are not supposed to treat it as business profits. The surplus shall not form part of business profits. Shree Limited decides to spend and utilize the amount of CSR on the activities for the benefits of all the employees of Shree Limited. Can I do it? Definitely no. Why? Any amount spent on my employees or on their families will not be treated as CSR because it is your duty. It's not corporate social responsibility, no, it is your duty to take care of your employees. So, no amount spent on CSR activities by Shree Limited for that financial year. Be considered you didn't spend even 1 rupee as CSR. The registered office of Bharat Limited is situated in a classified backward area of Maharashtra. The board wants to keep its books of accounts at its corporate office in Mumbai, which is conveniently located. The board seeks your advice about the feasibility of maintaining the accounting records at a place other than the registered office of the company. Can I maintain it? Absolutely fine, people. You can maintain it. Only thing is, you need to intimate the registrar, sir, my new place of business where I am maintaining it is this place. You just have to intimate registrar and you need to pass a board resolution. Once you pass a board resolution, within 7 days you need to intimate the registrar. You will intimate in the form AOC 5. That's all. Remember, people will get confused here and you will write off special resolution. You will get confused with the register of members provision. This is different. The board of directors of Vishwakarma Electronics Limited consists of Mr. Ghanshyam Haidar and Mr. Inderson, managing director. The company has employed a company secretary. The financial statements the company were signed by Ghanshyam and Mr. Haidar. Examine whether the authentication of financial statements of the company was in accordance. Is it right? Possible? Correct? The answer is, people, remember the financial statements, people, shall be first signed by who? Chairperson of the company, if at all he is authorized. Sir, what if chairperson is not authorized? In such case, people, it shall be signed by 2 directors of the company. And if your company has a managing director, then managing director should mandatorily sign. And if your company has CEO, CFO, CS, all three are there, all 3 should sign. So it shall be chairman or 2 directors. In that, if you have MD, 1 MD. If you have CEO, CFO, CS, all 3 has to sign. In our case, Inderson is mandatory and CS is mandatory. In our case, they are not signed, so the signing is not as accordance with the law. A Housing Finance Limited is a housing finance company having a paid-up capital of 11 crore and turnover of 145 crore during the financial year. Explain with reference to the relevant provisions and rules whether it is necessary for a housing finance limited to file its financial statements. XBRL people, according to the terms, yes people, paid up capital 5 crore, turnover of people, you are 100 crore, both satisfied. However, if you are a housing finance company people, then you are exempted. So, XBRL is not mandatory. Heavy Limited is a company registered in Thailand. SKP Limited, registered in India, a wholly owned subsidiary company of Heavy Limited, decided to follow different financial year for consolidation of its accounts. State the procedure. Is it possible? Yes, people. Where a company, if it's a holding company, subsidiary company, or an associate company of a company incorporated outside India, I can follow a different financial year. How? I need to, for the purpose of consolidation, I need to file an application to the central government, and the central government will allow me to follow a different year. Even if it is not a financial year, it's absolutely okay. They will allow me to follow a different financial year. Ravi Limited maintained its books of accounts under single entry system of accounting. Is it permitted? No, double entry. State the person responsible for complying with the provisions. Whole-time director in charge of finance, managing director, CFO, or such other person authorized by the board. These are the people who are they are under the obligation to maintain the books of accounts. Whether a company can keep books of accounts in electronic form, accessible only outside India? No, people, not possible. It should be accessible in India on a daily basis. Yes, and the backup should also be maintained in India. Correct? People, in your book, there is some things that have changed. See, this is an amendment. What is that? It should be accessible at all the times. So you can keep a backup. You can maintain outside India, but you should have a backup in India, which should be accessible at every given point of time. Next one is you need to maintain the electronic mode. You need to maintain such accounting softwares which mandatorily have a audit trail feature, that is which is able to capture the edit logs. Who edited, who did not edit. This was made mandatory from 1st April. It was first 2022. Later it got again amended. They said it is mandatory from 1st April 2023. Now this is the thing. In your books it will be 2022. Next one, the backup of the books of accounts and other books shall be maintained, including at a place outside India, if any, shall be kept in servers physically located in India. One server should be there in India at least. It is not on a periodic basis, it should be on a daily basis. So the servers should be in India. So one backup should be in India. Correct? So completely maintaining outside India is not allowed. The government of India is holding 51% of paid-up equity share capital of Sun Limited. The audited financial statements of Sun Limited for the financial year were placed at its AGM held on 31st August 2023. However, pending the comments of Comptroller and Audit General of India on the said accounts, the meeting was adjourned without adoption of the accounts. 31st is when they conducted, it was adjourned, the financial statements was not adopted. On respect of CAG comments on the accounts, the adjourned AGM was held on 15th October 2023. Whereas the accounts were adopted, thereafter Sun Limited filed its financial statements relevant to the financial year with the ROC on 12th November 2023. Examine with reference to the applicable provisions whether Sun Limited has complied with the statutory requirements. No, people, Sun Limited has not complied with the statutory requirements. Why? Whenever a company has conducted an AGM but they have not, or they were not able to adopt the financial statements, in such case what happens? You have to file the unadopted financial statements only with the ROC. ROC would have taken that as provisional. In the given case, they have not filed the unadopted financials. They directly filed the adopted financials on 12th November. This is correct. Within 30 days you filed it. But you did not file unadopted, so that is a non-compliance. Correct? The income tax authorities in current financial year observed during the assessment proceedings a need to reopen the accounts of Chetan Limited for the financial year 2012-23, 2012-13, and therefore filed an application before NCLT for reopening the accounts. Examine the validity of the application. The maximum we can reopen is people 8 years. So calculate is it 8 years. The current financial year is people 23-24. Exclude that. 22-23 will be your first year. Take it. According to me, you are getting it 11th year or 10th year. So definitely it is not possible. Correct? Yes. Okay. 1 second. Yes, people. Next chapter, chapter 10. The Birthday Card Limited, a listed company, can appoint or reappoint Mishra and Associates, a firm, as their statutory auditors for firm people. So 2 terms of 5 consecutive years. Every company shall at the first AGM appoint an individual or a firm as an auditor who shall hold office from the conclusion of the meeting till the conclusion of 6th AGM, right? For appointing an auditor other than retiring auditor, you need a special notice, section 115. State the procedure for following, explaining the relevant provision of Companies Act. Appointment of first auditor when the board of directors did not appoint the first auditors within 1 month from the date of registration of company. It depends upon which type of company, right? If you're a normal company, within 30 days, if the board fails, then within next 90 days, the shareholders will have to appoint. If it is the case of, what do you call the government company, if at all the board fails, next the CAG will have to appoint. If CAG also fails, next the shareholders will have to appoint. That's the thing. That's one thing. Remember and go. There is one more question. Okay, removal of statutory auditor before the expiry of his tenure. How people? First, I need to conduct a board resolution. I need to apply to central government. If central government gives me an approval, people, within 60 days of the central government's approval, I need to conduct a shareholders meeting. I need to pass a special resolution, and then I can remove a auditor. Remember. Okay. And which form you will file with central government? ADT 2. 1/4 of subscribed capital was held by government of Rajasthan. 1/4 is 25%. So it's not a government company. Mr. Neeraj, a chartered accountant, was appointed as an auditor of the company at AGM held on 30th April 2024. AGM itself was held on 30th April 2024. He was appointed by an ordinary resolution. Mr. Sanjay, a shareholder of the company, objects to the manner of appointment of Mr. Neeraj on the ground of violation of the Companies Act. Decide whether is it tenable. Also examine the consequence of above appointment under the said act. Is it valid? Yes, people, valid only. Remember, any matter, people, adda is there? No. Everything is done by ordinary resolution only. We will not do any of the adda items through special resolution. So appointment by a person in AGM is valid only. So there is no no problem and all. EF Limited appointed an individual firm, Naresh and Company, Chartered Accountants, as auditors of the company at the AGM held on 30th September 2023. Ms. Kamala, wife of Mr. Naresh, invested in the equity shares face value of 1 lakh of EF Limited on 15th October 2023. But Naresh and Company continues. Absolutely fine, no people. Wife has held. Relative can hold up to 1 lakh. So absolutely fine. That to what? I can hold up to face value 1 lakh. Market value Allah. So absolutely fine. Explain how the auditor will be appointed in the following cases. A government company, I just told you. The first auditor, board, CAG, and then shareholders. In the case of subsequent, CAG will appoint the auditor within 180 days of commencement of financial year. Subsequent auditors, correct? Okay. So government company within a meaning. So how do we appoint people? The first auditor will be appointed by what? The first auditors will be appointed by CAG, board, and then shareholders. Subsequent will be appointed by CAG within 180 days. Correct? Okay. Did I tell the order other way? The first auditor shall be appointed by Comptroller and Auditor General of India within 60 days from the date of incorporation, and in case of failure to do so, the board shall appoint the auditor within next 30 days. And yes, I think when I said board first. For government companies, CAG, and then is board, and then is shareholders. Subsequent within 180 days from the commencement of financial year. Second one is board. A public company whose shareholders include XYZ Bank, a nationalized bank holding 18% of the subscribed capital of the company. It does not make it a government company. So how will you appoint? So first one is board directors, 30-90 days. If not, subsequent people will be in the AGM. There will be no change in that. That is as it is same. Whenever an auditor is appointed, you need to intimate the registrar within 15 days of appointment of the first auditor in the form ADT 1. Examine the following situations in the light of Companies Act. Mr. Abhi, a practicing chartered accountant, is holding securities of Abhiman Limited having face value of 1000. Whether Mr. Abhi is qualified? Absolutely no. The auditor cannot hold even one share. Examine whether the following persons are eligible for being appointed as an auditor. Mr. Prakash is a practicing chartered accountant, and Mr. Akash, who is a relative of Mr. Prakash, is holding securities of face value 70,000. Market value is 1 lakh. Market value ignore. Face value okay. Relative can hold. Absolutely fine. So Mr. Prakash is valid. You can appoint. Mr. Ramesh is a practicing chartered accountant indebted to MLB Limited for rupees 6 lakh. People, me, partner or relative, not beyond 5 lakh rupees. Individually it is. So this is disqualified. Ramesh is disqualified. Ms. KVJ, spouse of Mr. Kumar, a chartered accountant, is a storekeeper of PRC Limited. Directors of PRC Limited want to appoint Mr. Kumar as an auditor. Possible. Storekeeper people, absolutely fine. Director and KMP, you cannot be. Any other position, absolutely fine. So yes, Kumar can be a auditor. The board of directors of A Limited requested its statutory auditors to accept the assignment of designing and implementation of suitable financial information system. Can I do it? I know people, disqualification of an auditor. I cannot take up services under section 144, which includes designing of financial information system. So I cannot do it as an auditor of the company. So yes, I cannot take it up. Consequence, people, I'll have to either step out as an auditor. If I still continue to do, then I'll be liable under section 147. That's all. Okay, done. Chapter 11, Jackson Communications LLC incorporated in Arizona, USA, has established a principal place of business at Kolkata, West Bengal. It is required to deliver requisite documents to the specified authority. You are required to select an appropriate option. As and when a foreign company establishes its place of business in India, you need to intimate people, registrar within 30 days, people, registrar, New Delhi. Now the work has been delegated to CRC. You need to file everything within 30 days. Morgan Stern Digi Cables Incorporated in Berlin, Germany, established a place of business at Mumbai to conduct its business of data interchange and other digital supply transactions online. However, Morgan Stern failed to deliver certain documents to the jurisdictional ROC within the prescribed time period in compliance with the respective statutory provision. Which option out of the four given below shall correctly indicate the amount of fine which it shall be punishable? Minimum will be 1 lakh rupees, people. It can go up to 3 lakh rupees minimum itself. And for each continuing day of default, you will be liable for 50,000 rupees. That's the penalty. Yeah. Just 1 second, people. 1 lakh, 3 lakh. Okay, 1 lakh, 3 lakh, 50,000. Radix Healthcare Limited, a company registered in Thailand, although has no place of business established in India, yet it is engaged in online business through remote delivery. Online is also okay, Noda. Select the incorrect statement from those given below. Incorrect. It is a foreign, it is a foreign, it is a foreign, it is not a foreign. This is incorrect. It is a foreign company. Whether you are present online or offline or through agent, who cares? You are a foreign company. 5K Cosmetic Shop PLC, a company incorporated in Switzerland, is involved in digital supply services through electronic mode. The server of which is located outside India. The company follows calendar year as its financial year. Every year, the company is required to prepare a balance sheet and P&L account. You are required to choose the correct timeline within which such documents should be filed. Within what, people? Within 6 months from the closure of financial years, I need to file it with ROC. I need to file all the financial statements. ABC Limited, a foreign company having its Indian principal place of business at Kolkata, West Bengal, is required to deliver various documents to ROC under the provisions of Companies Act. You are required to state where the said company should deliver such documents. Where will it deliver? It will deliver to New Delhi. But now, yes, we have a lot of things has been now delegated to CRC. In case a foreign company does not deliver its documents to the register of company as required, then what will be the penalty? As I told you, 1 lakh, 3 lakh, 50,000. Try to remember and go, important. Yes, sir. Every officer shall be liable to a penalty which shall not be less than 25,000, but which may go up to 5 lakh. Deji is a company limited incorporated in Singapore, desires to establish a branch office at Mumbai. You, being a practicing chartered accountant, have been appointed by the company as a liaison officer for the compliance of legal formalities on behalf of the company. Examine the provision of Companies Act. Answer the following: whether branch office will be considered as a company incorporated outside India. If yes, state the documents you are required to furnish on behalf of the company on establishment of branch office at Mumbai. Branch office will be considered as place of business, people. That's absolutely fine. You will be considered as a reflection of your parent company only. So yes, it will be considered as place of business in India. And state the documents you are required. You need to give the details of your directors, your place of address of principal office in India. On the previous occasions when you had come here, when you had closed your registered office. Details of your director, secretary, and details of one authorized officer in India, and have you complied with all the FEMA rules, approvals, as the case may be. You have to give, and you should have not been suspended. The director or authorized representative should not be suspended from forming or management of such companies, whether in India or outside. All the documents has to be in English language. If not, you need to file a translated copy. Galileo Limited is a foreign company in Germany and it has established a place of business in Mumbai. Explain the relevant provision of Companies Act and rules made thereunder relating to the preparation and filing of financial statements. I have to do it, people, within 6 months from the closure of financial year. I have to I have to give all the details, not only of one branch. If there are more than one branch, I have to give all these details in the form FC2. Yes, and as the case may be, correct? Sorry, my bad. Where is that? Okay, FC3. Sorry, all the details of the. Okay, FC2 is if at all there is any change in the details of the. Details you have filed for setting up the place of business in India. If there are any changes, you need to file FC2. This is FC3, correct? My bad. So all of this you need to file, and everything has to be in English language if it is not in English language. Okay, within a period of 6 months. In the light of provision of Companies Act, examine whether the following companies can be considered as foreign company. Redstone is a company registered in Singapore. The board meets and executes business decision at the board meeting held in India. Only board meetings conducted in India, people, will not be considered as business activity in India, and hence it is not considered as a foreign company. Zen Limited Liability Company, registered in Dubai, has installed its main server in Dubai for maintaining office automation software by cloud cloud computing for its client in India. Remember people, that means what you're serving, your servers are outside, but you are providing a service through electronic mode in India. In such case, what will happen people, you will be considered as foreign company, not yes. Abroad Limited, a foreign company without establishing a place of business in India, proposes to issue prospectus for subscription of securities in India. Being a consultant of the company, advise on the procedure. If you remember people, while you see the prospectus provision, it clearly says what? If you are a company incorporated outside India or not, whether you are incorporated or not, you are going to incorporate, or you are incorporated outside India, you have a place of business in India or not. It is still optional. So even if you do not have a place of business in India, you are still allowed to issue prospectus in India and you are allowed to raise the money from Indian market. So in this case, is it allowed? Yes, it is allowed. The documents has to be signed by the chairperson or it shall be signed by two directors. The chairperson of the company and the two directors of the company shall be signing these documents and need to deliver everything to the registrar. That's the condition that you need to follow. That's all. Correct? Huh? Jackson and Jackson LLC Incorporated in Germany is proposing to establish a business in Mumbai. Its official documents are in German language. Is it okay? You need to always file a certified translated copy. So it has to be certified translated copy. Swift Pharmaceuticals, a company registered in Singapore, has started its business in India during the financial year 2016. The company has submitted all the required documents with registrar within the due date. On March 1st, 2024, Swift Pharmaceuticals has shifted its principal office in Singapore. Does the company require to undertake the steps due to change in address of principal office? As I told you, FC2 will be filed. In FC1, we file all the details to ROC. When we come and establish our place of business in India, if any change happens in that details, people, we need to inform in the form FC2. So the change of principal office, you need to intimate in the form FC2. Yes, ma'am. Clear, ma'am? Hello. Yes, people. So let us start with the next chapter, LLP. Easy breezy. Which of the following cannot be converted into a LLP? Remember, private, public, everything can be converted into an LLP except a listed company. A listed company first has to convert itself into a unlisted public company and then only you can convert into a LLP. Directly, if you are a listed, you cannot convert yourself into a LLP. Not possible. Correct? Okay. Next one, sir. The approved name of LLP shall be valid for a period of 3 months. Name of the LLP shall be ended by the words LLP or limited liability partnership. Which one of the following statements about LLP is incorrect? An LLP has a legal personality separate from that of its members. The liability of each partner in LLP is limited. A listed company cannot be converted. That we have seen. For the purpose of LLP, resident in India means 120 days. Remember, the only thing you guys have to remember is when you are seeing for OPC, it will be in the preceding financial year. If you are checking for LLP, it will be during the financial year. This one thing you guys have to remember. Correct? Yes. One sec. This is better, huh? I think there was some clarity issues. Okay. Then LLP is an alternative corporate business form that gives the benefits of limited liability of a company and flexibility of a partnership. Explain. Nothing but it is a hybrid instrument which has both the features of company as well as partnership. Majority of the features are taken from the company, but some features are also taken from the partnership. Like in the partnership, everything runs on a partnership deed. Here, everything runs on a LLP deed. That means it is more flexible. So you can decide everything by your LLP agreement. That is your flexibility. And we have the concept of partners, and basically the owners and the managers are same, unlike the case of the company. So yes, like this we have various advantages that we have taken from the company also, from the partnership also. But a direct question. Mr. Ankit Sharma wants to form a LLP, taking him, his wife, Ms. Archika Sharma, and one HUF as partners for that. Whether this LLP can be incorporated, can we do it, people? These two people, we don't have a problem. As long as you're a sound mind, solvent person and a major, you can be a partner in a LLP. However, what and all is considered as body corporate? What is that? LLP incorporated in India, LLP incorporated outside India, company incorporated in India, company incorporated outside India. Whereas people, HUF is not covered in the definition of body corporate, and hence HUF cannot be considered as a partner. Not possible. There is in fact a clarification also given by the ministry. There is an LLP by the name Ram Infra Development LLP, which has 4 partners, namely Rahul, Rahim, Kartar and Albert. Rahul and Albert are non-residents, while other 2 are residents. LLP wants to make Rahul and Rahim as designated partners. Rahul and Rahim as designated. Explain in light of LLP whether LLP can do so. Is it possible? Yes. We need to have at least one resident in Indian, correct? Here in our case, Rahul is not resident, but Rahim is resident, and that is fine for us, correct? So fine, yes, that is possible. Mr. Mudit is a creditor of Devi Ram Food Circle LLP. He has a claim of 10 lakh against the LLP, but the worth of the assets of LLP are only 7 lakh. Now, Mr. Mudit wants to make the partners of LLP personally liable for the deficiency of 3 lakh. Whether by virtue of provisions of LLP, Mr. Mudit can claim the deficiency from the partners of Devi Ram Food Circle LLP. Is it possible? Remember, people, it is not possible because of limited liability. The LLP will be liable only to the extent of 7 lakh, and the 3 lakh is a loss for the creditor. You cannot recover it from the partners because of separate legal entity concept as well as limited liability concept. Measures Vardhaman Steels LLP was incorporated in 1st September 2022. On 1st Jan 23, one partner of a partnership firm named Measures Vardhaman Steels is registered with Indian Partnership Act 1932. Since 1st Jan 2000, requested ROC that as the name of LLP is nearly resembles with the name of already registered partnership, the name of LLP should be changed. Explain whether Measures Vardhaman Steels LLP is liable to change its name. Very, very important. Remember from exam point of view. What is that, people? Now, when will this particular similar identical name, that section will apply? Section 15. When does it apply? Also section 17, read together. If you see, one thing it says what? Whenever the name is identical with a similar name of an LLP or a company or a registered trademark, then you need to change the name within 3 years. Now, people, in our case, who is making the application? The application is made by a partnership firm which is registered under Indian Partnership Act. The section does not give a right for the partnership firm to come and file a case under this particular section. It is only for LLP, company as well as registered trademark holders. In the given case, if this partnership has also a registered trademark in the same name, they can come and request for the change of the name. That is okay. But if that is not the case, people, then you cannot request for a change name. And hence, in our case, Vardhaman Steels LLP is not liable to change its name because their partnership firm is not covered under this particular section. Kanik, Priyansh, Abhinav and Bhavna were partners in Singh, Jain and Associates. Abhinav resigned from the firm with effect from 1st November 2022. But this was not informed to ROC by LLP or Abhinav. Whether Abhinav will still be liable for the loss of the transaction of entered after 1st November 2022, when will the liability of the partner cease, people? The liability of the partner ceases with regards to the third party. So the third party is entering into a contract with the LLP. When will the partner not be liable for the third party? First scenario, people. Are you aware of this particular scenario? Yeah, are you aware of this particular scenario? That means what? That so and so person is not a partner. Are you aware? If you are aware, people, then the third party cannot bind the partner to this contract. Second scenario, people, the LLP has informed the registrar about such resignation, or the partner has informed about such resignation. So if any of this is satisfied, then people, the partner will not be held liable. In the given case, neither the third party knows, neither have we informed the registrar, and hence the partner will be liable even after his resignation. Remember, if you think LLP does not inform, you can inform, no? You have that option. Yeah. Done. Next chapter, people, let us do it off. The General Clauses Act 1897. Which one of the following is not a immovable property? Easy breezy. Timber. Why timber goes under a different act to your childhood? Soga. Correct? What is timber, people, in general? Timber is nothing but a wood which is agreed to be cut, or it is already cut. We generally use it for the purpose of furniture or in the purpose of construction of a house. That's the logic behind not considering timber as a immovable property. It's a wood specifically grown for the purpose of construction or cutting. So we will not keep the timber forever. That's why it does not come under immovable property. Where an act of parliament does not expressly specify any particular day as to the date of coming into operation of the act, then it will come into the operation whenever the President of India signs or the governor signs, if it's a state act. An act or omission constitutes an offence under two enactments. Referring to the provision of General Clauses of the Act, state which among the following is correct. So people, remember, if at all you have committed an offence which is covered under two acts, then you can be prosecuted under both the acts, but you cannot be punished under both the acts. You need to be punished in any one of the acts. See, the offender shall be liable to prosecute and punish under that either or any of the enactments, but shall not be punished twice for the same offence. That is my thing. Correct? Hello? Every act has a dash which express the scope, object and purpose of the act. Preamble, people. What is financial year? An year which starts with April and ends with March. What is immovable property under General Clauses Act, people? Land, any benefits arising out of the land, any things attached to earth, or anything permanently attached to anything attached to the earth. So these are considered as what, people? Immovable property. Exam point of view, General Clauses Act, immovable property definition, very important. Remember and go. As per the provision of Companies Act, a whole-time KMP shall not hold office in more than one company except its subsidiary company at the same time. Referring to the section 13 of General Clauses Act, examine whether a whole-time KMP can be appointed in more than one subsidiary company. Important, people, this is not there in our text, but it is there in our questions of textbook. So once they have asked this question directly in the exam, people will wondering, why have they asked this whole-time KMP? Why is this provision there? This is not there. This is not been asked from Companies Act. This question is taken from here and it has been asked. Now what does it say? There is a section, people, in Companies Act which says if you have a KMP, we have no KMP definition. Section 2 clause 51, we have it, no? According to that, it says a KMP cannot be a KMP in more than one company. Exception is you can be a KMP also of your subsidiary company. That means what? Let us imagine if I am a CFO or say for example CS of a holding company. Law says you should not be a CFO or a CS of any other company. You can only be for that one company. One exception was you can be a a KMP of even the subsidiary company of such holding company. Now imagine if you have a subsidiary company, here also you can be a CFO or a CS. It is allowed. Now the words used in the law is people, you can be a KMP of such a subsidiary company. Now the question is, what if this holding company has two subsidiary companies? Can I be a CFO or a CS of both the subsidiary companies or only one? So they connected this provision of Companies Act with General Clause Act. Is it possible? The answer is people, yes. And what is the reference they have given people from General Clause Act? Which reference they have given? They have given the reference people as what? Remember, whenever there is a person, whenever in the law, if they have given a reference to singular, singular might include plural as well. So here the word subsidiary, when you interpret it, you need to interpret as if it's a plural, subsidiaries. So the law has given reference to one. You can appoint such person as a KMP in more than one subsidiary company. Allowed. That is the answer. Allowed. I mean, understood? Clear? Notice when required under statutory rules to be sent by registered post, acknowledgement due is instead sent by registered post only. Whether the protection of presumption regarding the serving of notice by registered post under General Clauses Act is tenable. Referring to the provision of General Clause Act, examine the validity of such a notice. What are these people? Nothing but in our General Clause Act, we have clearly seen under section 27. What is that? Now, whenever I have to send someone something by post, whether that person receives it or not, my obligation is completed the moment people, if I have addressed it properly, if I have prepaid that postal charges. Third one, I have clearly sent it by a registered post. If these three conditions are satisfied, people, then my obligation is done. You can't hold me liable. However, let us imagine in one law, they have clearly written, what is that? You need to send it by such a registered post which is having an acknowledgement due. Meaning a clear acknowledgement should be given that the post is delivered to that person or not. Such acknowledgement is to be taken. An act has written it. When the act has specifically written it, but if you do not send it by a registered post which is having an acknowledgement due, but you send it instead only by a registered post, they're asking you, according to General Clauses Act, have you served the purpose? The answer is no, people. Always remember, General Clauses Act will come into picture when the act is ambiguous or it is silent. When some act clearly says that people, you need to send it by a registered post which is having an acknowledgement due, you cannot just wash off your hands by sending something just by a registered post. So, no, according to General Clauses Act, this provision does not apply to the scenario itself because the law in that statute is clear. So, it is not tenable. I hope you guys understood. Now, next one, X owned a land with 50 tamarind trees. He sold his land and the timber to Y. X wants to know whether the sale of timber tantamounts to sale of immobile property. Advise him with provision of General Clause Act. With 50, he sold his land and timber. People, this is immobile property. This is not immobile property. That's all. Okay. What is the meaning of service by post? I told you 3 things you need to remember. What is that? One is properly addressed, prepaid and registered post. Komal Limited declares a dividend for its shareholders in its AGM held on 27 September. Referring to the provisions, advise the dates during which Komal is required to pay the dividend. First, people, don't count 27. From 28th of September, please count 30 days. The 30th day is inclusive. Don't count 27 September, take it from 28th, 29th, 30, 3 and then 27. So it will be what, people? 27th of whatever is the next month, October, 27th of October. That will be my last day. By 27th of October, I need to pay. Simple. 27th is inclusive. The dates during which Komal Limited is required to transfer the unpaid or unclaimed dividend. So from there, people, 7 days. Don't count 27th. Count it from 28, and then count 7 days. When will that be? 28th to 3rd November. So 3rd will be considered as people I have to transfer to unpaid dividend account. I hope it is clear. Don't count to the first day, count to the last day. Repeal of provision is different from deletion of provision. Explain. People, simple people, what is the difference between repeal and deletion? Repeal means people, even the roots will be eliminated. The words used in the law will be people. Whenever we are using the word repeal, in such case, what we are doing? We are going to obliterate. What do you mean by obliterate? Means people, we are going to pluck off the provision right from its roots. So no one would even know that such provision existed. For example, let us imagine there was a rule, yeah, that if you do a, I don't know, something like say, I'm just giving you a very vague example that comes to me. Say, for example, theft. If at all there is a theft, people, it will be punishable. Imagine there was a rule. And that rule was, let us imagine, that rule was repealed. Second provision is that rule was deleted. When was this rule repealed or deleted? Let us imagine the rule was deleted on Sunday. Yeah, it was repealed and deleted. Let us imagine, people, if it is repealed on Sunday, but we got to know on Monday that 2 days back on a Friday there has been some, someone has done a non-compliance. We get to know that. But if at all the words repeal is used, means people, that entire section itself will be removed. There will be no roots also. So once the provision is repealed, you cannot have any justice in the court. It is done. It is removed. We wouldn't even know that such rule existed. But if we have used the word deleted, so we have deleted it on Sunday, right? So on Saturday or Friday, some instance, if at all it had happened, even though on Sunday we have deleted, you can still take action. If at all the words repeal is used, you cannot take action. Obliterate means, people, we will even forget that such particular thing existed. Here, the roots will still exist. That's the main difference. Clear? Okay. Next one, sir. The Companies Act 2013 provides that amount of dividend remained unpaid or unclaimed on expiry of 30 days shall be transferred within 7 days from the date of expiry. Okay. If the expiry date of such 30 days is 30th October, decide the last date, which we have already seen, people. You need to take it from the 31st of October. 31st of October will be your first day, and take 6 days in November. So 6th November. Referring to the provision of General Clause Act, find out the day or date on which the following act or regulation comes into force. Give reason also. An act of parliament which has not specifically mentioned a particular date. Then from the date mentioned, from the day the President of India or Governor signs. The SEBI was issued wide notification dated 14th August with effect from 1st January. Remember, even if the notification was issued on 14th August, when the date is specifically given, the law will be effective from this day. So 1st Jan 2016. Okay, done. Next one, people, iOS. The rule in Hayden's case, here I wouldn't be doing much because everything will become theoretical here. I would rather suggest you to please watch marathon under this particular time rather than this. The rule in Hayden's case is also known as, people, what? Mischief rule, right? Pick the odd one out from the following aids to interpretation. Preamble, marginal roads, provision, usage. Correct? These are all internal aids. Dash is the cardinal rule of construction. What, people? Literal construction. It's the first rule. An internal aid that may be added to include something within the section or to exclude something from the section is considered as what? The internal aid that may be added to include something within the section or to exclude something is called as what, people? According to me, this has to be provision, not explanation. To include or exclude, provision people, not explanation. When there is a conflict between two or more statutes or two or more parts of a statute, then which rule is applicable? Welfare is strict to harmonious, of course. Explain the rule in Hayden's case while interpreting the statutes. What is Hayden's case, people? Hayden's case is nothing but you need to know what was the law before, what was the remedy the law before did not provide, and what is the remedy this law is trying to provide. You need to apply these questions and you will get an answer by yourself. Explain the principles of grammatical interpretation and logical interpretation of statute. What are the duties of a court in this regard? Grammatical means, people, nothing but you are going by the letter of law. If you are going for logical interpretation, you are always going with the spirit of law. Like in the class, I would have given you an example of, let us imagine if a park has a board saying that vehicles are not allowed inside. Now, what do you mean by vehicles are not allowed inside? Can I not take even a baby stroller? Can I take a wheelchair of a patient? Can I take a cycle? What do I mean by vehicles here? So if I go with the letter of law, that's all. Stroller also is not allowed. Wheelchair is also not allowed. And chair, what is that? Cycle is also not allowed. Logical people, I'm telling probably something which is very fast, very harsh, which causes pollution. I'm telling about that. That's the difference between letter of law, spirit of law. For example, we tell, right, all of you to become CA, you need to clear your CA final. Letter of law I have to clear. Can I copy and clear? Spirit of law, I need to clear it with clean hands. What is the effect of proviso? Does it qualify the main provision of an enactment? Does an explanation added to a section widen the ambit of a section? So, what do you mean by this, people? What is that? Proviso. Proviso means what, people? Proviso means generally, yes, whenever there is a rule, for that rule, if you want to provide an exception, in such case, what do? We will use the word called as proviso. If I have to give you what do you say, an example also, I can give you in the case of private company. See, generally when you are taking in a company, if your employees are your shareholders, you have to count them as your shareholders. You have to count them in a number. But in private company, what have they done? They have used the word called as provided. The past and present employees shall not be included in the number of members. That means what? They have given you an exception. So provision means what? There will be some qualification. Yes, sir. Next one. Sometimes explanation. Okay, my bad. Here you can take it as explanation only. They have taken the textbook into. Okay, you can take explanation only. This is B. Yeah. So what can come under explanation then? Explanation will be generally, people, nothing but it's a section where which can add something or exclude something from the particular section. Correct? Okay, the best example I can give you of an explanation is, people, associate company. What do I mean by the word significant influence? It is adding, no? Anything which is 20% up to 50%. We are adding it, no? Yeah. Next one, Gaurav Textile Company Limited has entered into a contract with the company. You are invited to read and interpret the document of contract. What rules of interpretation of deeds and documents would you apply? What are the people? First thing is that, people, you need to keep in mind while you are trying to understand the words used, you need to keep in mind that who has drafted it. Is it a normal man, or is it a document which is drafted by any people with a particular background? Based on that, people, the meanings of the words will be derived. For example, if an advocate has drafted a document and if he has used the word called as possession, that means he is trying to say it is ownership. Title, he is trying to say it is ownership. Correct? But what if a normal person is using it? That means I am trying to tell something called as custody. Correct? So if a software engineer is using the word person, that means he is just meaning to be individual. What if a commerce student is using the word person? That means I might be telling I am including a LLP, company, partnership, and individual. I'm trying to include everything in this particular definition, correct? And second rule is that, remember, in the same contract or a deed, one word can never have two meanings. So in the first place, if a word possession means title, even in the last sentence, if the word possession is used, even that should also mean title only. Correct? Next one, try to understand the words in its ordinary sense and natural sense. And you need to read the document as a whole. Never read it in parts. You need to keep in account what is the status and training of the parties who have entered into an agreement. This is what I told you. What is the background? So keep these things in mind. How will you interpret the definitions in a statute if the following words are used? Means. Means is always, people, exhaustive. You can't stretch it anymore. Includes means, people, it's like an example. It is extensive. You can add more to it. Differentiate mandatory provision from directory. Mandatory means, people, we would have used the word called as shall. Directory means, people, we would have used the word called as may. Mandatory is something which enforces a particular thing on a person. You do not take it as an optional. You have to do it. It is a mandate. Directory is discretion, voluntary. If you want, you do it. That's the difference. Define grammatical. I already told you. The wheelchair. When can the preamble be used as an aid to interpretation? Generally, people, we can use it only when it is when the act is ambiguous, when the section is unclear. Only then you can use preamble. When the section is very clear, in such case, people, you cannot use preamble. And always remember, see, where there is an ambiguity in the words of an enactment and where the words of an enactment appear to be too general in scope. For example, Bandaru Pavani, there is a case in our book. We need to remember that. Correct? That is where we have referred to preamble. The marriage between two Hindus. Correct? That case law. Explain how dictionary definitions can be of great help in interpreting or constructing an act. Remember, people, before going to dictionary definition, it is our duty to first refer to the definitions used under the act. If the sections used or if the meaning is not clear, or if the sections or the definitions given in the act, if it is unclear, only then you can seek under dictionary definitions. But if the internal definitions are clear, you have to refer to the internal definitions. This becomes an external aid. Preamble does not override the plain provision, as I told you. So preamble cannot be considered as a rule. Only when the section is unclear, we try to refer to the preamble. When the when your section is clear, in such case, we will not refer to preamble at all. At the time of interpreting a statute, what will be the effect of usage or customs and practice? You need to remember two Latin maxims. What is that? One is called as optima legum interpres yes constitut. What do you mean by that? The custom is the best interpreter of law. However, a particular word has been used for a period of time, over decades, over generations. Try to use that word in the same sense. That is the first one. Second one is, people, contemporanea exposito yes optima yet forti senior in league. What do you mean by that, people? Nothing but the best interpreter of law. Basically, the best way to understand the law is to read it as if it would have been read when made. That means what? You can't sit today and you cannot say Indian Contract Act, how is it even applicable and how does it even make sense? For it to make sense, you need to understand as if today, even now, if we are using still letters, how would we enter into a contract? So if you can go into those days and if you try to understand, is when you will understand the law better. And that is what this particular maxim says. What does it say? Contemporanea exposito yes optima yet forti senior in league. That is the first meaning. What is that? The first meaning and the best meaning is, if you want to understand the law, you cannot sit today in today's circumstance and you cannot comment on it. If you want to understand it better, you need to read it as if how it would have been read when we made it. Like that, you need to read it today. And if at all there is any confusions during those days, if there was any authority formed, we generally call it as contemporary authority. If that authority has given us any clarification, we need to go and follow that clarification. For example, today if we are trying to read SEBI laws and SEBI has given us some clarification on it, I need to follow whatever SEBI has given. Because contemporary authority, that means an authority for SEBI, any clarification of SEBI rules, SEBI regulations, SEBI would have given. Now that becomes a proper law. Whatever is the clarification given by SEBI becomes the law. That is the meaning of contemporaneous exposito, contemporary authority. Exposito means expositor means what, people? The person who was there at those days as an authority. The person who gives you the law, makes law, explains the law. Anything given by him should be taken as a rule. Okay, the last one, people, FEMA. In September 2021, Mr. Purushottam Saha visited Atlanta as well as Athens and thereafter London and Berlin on month-long business trip, for which he withdrew foreign exchange to the extent of US $50,000 from his banker. In December 2021, he further withdrew $50,000 from SBI and remitted the same to his son Raviansh Saha, who was studying in Toronto. In the first week of Jan again the same year, he sent his ailing mother Savita Saha specialized treatment along with his wife Rashmi Saha to Seattle, where his younger brother Pranav Saha, holder of green card, is residing. For the purpose of his mother's treatment and to help Pranav Saha to meet increased expenses, he requested his banker to remit USD $75,000. In Feb 2022, Mr. Purushottam Saha's daughter Devyanshi Saha got engaged for destination wedding in August 2022 in Zurich, Switzerland. While on a trip to Dubai in the last week of March 2022, he again withdrew USD $35,000 to be used by him and Devyanshi Saha for meeting various trip expenses including shopping in Dubai. Later the event, the manager gave an estimate of $250,000 for the wedding of Devyanshi Saha at Zurich. Which option do you think is correct? First of all, check, people, in 21-22 how much of total money this person has spent. 50-50, $1 lakh plus 75 here, 1,75,000. I think this is March 22, which will still come under 21-22 only. So 1,75,000 plus 35 is 2,10,000. Correct? The wedding is in next year, so I want $250,000. So if you ask me, this is also valid, this is also valid. So we need to check which is the best chosen one. Answer says A. What does it see? In respect of withdrawal of foreign exchange on various occasions from his banker and remitting the same outside in India, Mr. Purushottam Saha is not required to obtain any prior approval. Correct? For both, right? It is within 2.5 lakh LRS. Next one, Measures Kedar Sports Academy, a private coaching club, provides coaching for cricket, football and other similar sports. It coaches sports aspirants pan-India. It also conducts various sports events and campaigns across the country. In 2022, to mark the 25th year of its operation, a cricket tournament is being organized by Measures Kedar Sports Academy in Lancashire, England. In first half of the April, the prize money for the winning team is 40,000 and for the runners up it is 11,000. You are required to choose the correct option from the 4 given below. First of all, people, see clearly they have given it's a private coaching. It's not a state body, national body or international body. If you are state, national or international, we don't have limit at all. If you are other than state, national or international, then people, the maximum I can spend in a year, people, cannot be more than $1 lakh. In our case, 40 plus 11, the maximum they are spending is $55,000. Sorry, how much? $51,000. So, do I have to take any approval? Answer is not required. For remittance of the prize money, 51,000 is not required to obtain any prior approval. I hope you understood. Akash Ceramics Limited, an Indian company, holds a commercial plot in Chennai which it intends to sell. Okay. Measures Superseller, a real estate broker with its head office in USA, has been appointed by Akash Ceramics Limited to find some suitable buyers for the said commercial plot in Chennai, which is situated at a prime location. Measures Superseller identifies Glory Estate Incorporated, based out of USA, as the potential buyer. It is to be noted that the Glory Estate Inc. is controlled from India and hence is a person resident in India. Under the applicable provisions of foreign exchange management, a deal is finalized and Glory Estate Inc. agrees to purchase the commercial plot for USD 6 lakh. Assuming 1 USD is 70. According to the agreement, Akash Ceramics Limited is required to pay a commission at the rate of 7% of the sale proceeds to Measures Superseller for arranging the sale of commercial plot to Glory Estate Inc. What is the maximum allowed, people? Correct? 5%, no? Okay. Glory Estate in USA. Considering the relevant provision of FEMA, which statement out of the four is correct? Which one is correct, people? Of course, the maximum. If you look at it, 7% into 6. 6 is 36, 7 is 42. So 42,000. 25, Allah, it is not coming. Ours is not 25. Ours is not 30. Ours is 42. No requirement of obtaining. He is mandatory to obtain. Of course, this one. Maximum allowed is 5%, no? Mohita Periodicals and Max Publications Limited, having registered office in Chennai, has obtained consultancy services from entity based in France for setting up a software program to strengthen various aspects relating to publication. The consideration for such consultant services is required to be paid in foreign currency. The compliance officer of Mohita Periodicals, Ms. Ritika, requires your advice regarding the foreign exchange that can be remitted for the purpose of obtaining consultancy services from abroad without prior approval of RBI. How much we can pay, people, depends upon what consultancy. Here they say software. If it is infrastructure, I can pay up to $10 million. If it is anything else, $1 million. That means $10 lakh. Yes, sir. Above that, people, I need to take RBI approval. After 5 years of stay in USA, Mr. Umesh came to India at his paternal place in New Delhi on October 25, 2025 for the purpose of conducting business with his two younger brothers, Rajesh and Somesh, and contributed a sum of 10 lakh as his capital. Simultaneously, Mr. Umesh also started a proprietary business of selling artistic brassware, jewelry, etc. procured directly from the manufacturers based at Moradabad. Within a period of 2 months after his arrival from USA, Mr. Umesh established a branch of his proprietary business at USA. You are required to choose the appropriate answer with respect to the residential status of Mr. Umesh and his branch for the financial year 2022. After considering the applicable provisions. So what is that, people? 2022? Of course, people, anything which is established directly in India, so that entity is considered as PRI only, and this fellow has come to the purpose of conducting business. If you have come into India for those three purposes, you are PRI only. So the entity is also PRI, he is also a PRI. That should be the answer. Okay. Next one, Printex Computer is a Singapore-based company having several business units all over the world. It has a unit for the manufacturing computer printers with its headquarters in Pune. It has a branch in Dubai which is controlled by headquarters in Pune. What would be the residential status under the FEMA? So first one, people, it has a unit in Pune. So anything directly having a branch office, agency, anything in India, it is directly PRI only. It has a branch in Dubai which is controlled by Pune office. So anything outside India but controlled by a person resident in India, even that will also be considered as PRI only. So in our case, both the branches are PRI itself. Mr. Sen, an Indian national, desires to obtain foreign exchange for the following purpose. Remittance of US dollar 50,000 out of the winnings on a lottery ticket. Prohibited transaction people, Schedule 1. US dollar 1 lakh for sending a cultural troupe on a tour of USA. Advise him. Can he do it? Yes, possible. He needs to take the prior approval. If yes, possible. By whom? Ministry of Human Resource Development. Basically today it is called Education and Culture. Take their approval, you can do it. Cultural troupe. State which kind of approval is required for the following transactions under FEMA. X, a film star, wants to perform along with associates in New York on the occasion of Diwali for Indians residing at New York. Foreign exchange drawal to the extent of US $20,000 is required for this purpose. Now, under what does it come under, people? Same, cultural tour only. I will go under Human Resource and Development. Now, cultural, Department of Education and Culture. R wants to get his heart surgery done at United States. Up to what limit you can take it, people? LRS. It will come under current account transaction. You can take it for medical treatment abroad. You can take $2.5 lakh per financial year. Sir, what if the treatment cost is more than $2.5 lakh? If the treatment cost is more than $2.5 lakh, please get an estimate from the respected hospital that for this particular operation, $2.5 lakh is not sufficient. You would need $5 lakh. Please get an estimate. Submit it with your authorized person. No need of RBI approval, people. No need of RBI approval. Directly it will go through. Okay. So in our case, that is a scenario. I hope this is clear. Just 1 second, people. There is a seminar going on. I need to join it. Okay, that's the answer. Referring to the provision of FEMA, state the kind of approval required for following transaction. M requires US $5,000 for remittance towards hiring charges of transponders. P requires US $2,000 for payment related to callback services of telebooths. Is it possible, people? Answer is no. Transponders, I need to take the approval from the IT, and this one, people, not possible. It comes under prohibited transaction. Central government approval is required. Next one, people, Suresh resided in India during the financial year 2020-21. He left India on 15th July 2021 for Switzerland for pursuing higher studies in biotech for 2 years. What would be his residential status under FEMA? People, here, the answer given is wrong, people. They have given some random dates and all. According to what book only follows, remember, the day you leave India, 15th, you will be considered as PRI only. You will become PROI from 16th of July. Because you are traveling abroad for education, it is clearly given by RBI circular that Anyone who travels for the purpose of higher studies or education, you will be treated as PROI. The clarification came in the year 2003, December. So a person will be considered as PROI from 16th July. So for both the years, you are considered as PROI only. Next one, Mr. Suresh requires every year USD $25,000 towards his tuition fees and $30,000 for incidental and stay expense for studying abroad. Is it possible? Yes, possible. You are willing, you can take up to $2,50,000. It comes under your educational purpose. Allowed. LRS limit up to 2.5 allowed. Mr. P has won a big lottery and wants to remit $20,000 out of his winnings to his son. Possible? Not possible. Prohibited transaction, schedule 1. Mr. Z is unwell and would like to have a kidney transplant done in USA. He would like to know the formalities required and the amount that can be drawn. I told you there is LRS by default 2.5. Beyond that, you can get an estimate low limit. Mr. Rohan, an Indian resident individual, desires to obtain foreign exchange for the following purpose. What is that? First one, USD 1,20,000 for the studies abroad on the basis of estimates given by foreign university. Allowed, because I told you 2.5. Gift remittance amounting to $10,000. Allowed, even that also comes under people, your FEMA only, your LRS limits only. Both are allowed to 2.5 lakh dollar. That's all. Look at it, bang on 100 pages. So people, that is your complete ICAI textbook questions. I'm also planning to do all the FEMA related questions which is covered in the past papers, your mock papers, your model test papers, RTPs, previous year questions, and your textbook questions, and everywhere whatever FEMA has been asked, I'm trying to cover it. I think easily we'll be able to make some 70 questions easily. Yeah, at least for the last 9 years, I'm going to cover it. 9 attempts, I'm going to cover it, people. So let me know if you guys want anything more. And there is already marathon uploaded. Please do watch it. It's for your benefit only. And if there is anything else you guys wanted, please let me know. Until then, thank you so much. See you all. Wishing you guys the best. Bye-bye.